Then I did discuss the members' input
Hayi. Hayi nisifaka enkingeni. Ngcono uma niseCape Town nje nomntana uganga.
Unale tie.
Hayi. Hayi thula wena.
I-birthday yakho inini ngizokuthengela utie.
Uqalile. Mfowethu.
Thanda le hembe lakho bona mawuvela ngale ngakithi emnambeni. Hayi babona ukuthi lengwenye ibuye Josi.
Hayi, ngathi ufuna ukuba inkinga nje.
Yeah, good morning everybody. Let me take this opportunity to welcome everybody in the meeting. Valerie, are we cooperating? Can we start the meeting? I can see some members. I've already greeted them. The Machironi Boramatwa. Ureni.
Rihone ringabusangeyo.
Zwabuti kakati ahona. Da. Valerie.
Chairperson, the meeting is collating.
Thank you very much. I have one apology on my side, written, and I must acknowledge Tandi Wempondo is doing well in terms of submitting written apologies. Do you have any other apology I'm missing? The apology I have here is from the minister, who has requested to join a subcommittee of the cabinet, ASET committee. Any other written apology, Valerie?
There is an apology from Ms. Noluchungu that we received this morning, Chair. The member is busy with organizational duties this morning and submitted an apology.
Thank you very much. So we have two apologies. So I take it that everybody is in the house. That is good. Without really much ado, we have about 5 items. The 6th item will be the item we like very much as a committee, the oversight, the program of oversight. We'll just touch upon it as we brush the meeting towards its logical conclusion. For those of us who normally say, why are we not beamed? I have seen that we are live on YouTube, and I want to say to the people responsible for that, Sibo, well done, well done. We are going to start with the A list of National Road Traffic Amendment Bill, Bill number 7, which was started in 2020. We are going to consider the proposed amendments to the bill. And I'm told that the legal people are ready now to take us through. And Parliamentary Legal Advisor Mephumelele Ngema, who's the other state law advisor? Is state law advisor here, Valerie?
Chair, Ms. Haricharan is in the meeting.
Ms. Haricharan?
Good morning, Chairperson, and to the members.
Can I see the face?
Morning, Chairperson.
The voice I hear, ma'am. I was requesting the face.
I've put my video on. Can you see?
I can see. Are you ready?
Chairperson, the Parliamentary Law Advisor and myself have discussed have done a combined draft of the A list, and by the Parliamentary Law Advisor will do the presentation. She's prepared a PowerPoint presentation, and when necessary, I will also comment when requested to. So, if that's fine.
Thank you
Chair.
very much. Thank you,
Chair.
Ms. Phumelele.
Good morning, Chairperson, and greetings to the members. Yes, I'm also here, Chairperson, and thank you for the welcome and thank you for the opportunity. I will start when the Chairperson says the go-ahead is ready, and I'm hoping also Valerie can help me with the sharing of rights, because Chairperson, I just want to use the presentation and the A list that I tweaked overnight just to add few clarities, Chairperson. Thank you so much.
If you are ready to go, I am borrowing the reins to run the meeting. We're going to run this meeting through your voice, I'm sure up until 11 o'clock. And I will then request you humbly to allow
Chairperson,
me to fulfill
Mange,
other agenda items. Are we
Mange.
together, Me Pumelele?
Thank you so much, Chairperson. I am with you. I see Advocate Alma has assisted me with putting up the screen for the presentation we must look at. Thank you so much, Chairperson.
Just before you start, there's somebody who's calling me in the meeting. I'm sure they can't raise their hand. Let me be kind enough to hear what they are saying.
I was just proposing that Mangata will have to adopt the agenda.
Oh, okay. The agenda has to be adopted. We normally don't. Okay. So you want to adopt the agenda? Honorable Ketamabala, let's hear you.
Yes, I propose that we do propose that the agenda must be implemented.
There's no much room, but let me get anybody who agrees with you.
I agree, Chairperson.
Thank you very much. Mondisa Siabo, for your contribution. Mamunge, Madlogov.
Thank you so much, Chairperson. Alma, may I have the second slide, please? Thank you so much, members. Thank you so much once again, Chairperson. At the stage that we are at now are the deep deliberations of the bill, B7 of 2020, National Road Traffic Amendment Act, as the Chairperson has pointed out. Chairperson, just a background, we've already deliberated as a committee on clause by clause, with the committee giving us directives on what needs to be effected as a draft bill that will be a B version bill. Also, Chairperson, to add is that there were other matters that while we were going through, the Chairperson and the committee did point out that we need to think them through and they might be flagged and we will come back to them. So some of those will be pointed out, Chairperson, with the suggestions that after the discussions and the persuasion of the members from what we took is then what we are suggesting, but it is not cast in stone because it is, as I said, the attempt to take and give effect to the directives and the instructions of the committee. So, Chairperson, I also need to point out that, as I said during our briefing and introduction, we are basically dealing with an amendment of an existing piece of legislation. And therefore, Chairperson, the issue about going on to sections that are outside of what the bill was introduced for as an executive bill and tagged as a section 76, there will be implications, and therefore that will also be noted if necessary on the suggestions that we provide. And therefore, once we get the final approval, the final product of the process we are engaging on now will be a B version of Bill 7 of 2020, together with an A list that will have to be confirmed and approved by the members. Can I have the second slide, Madam? Thank you, Chairperson. On the A list that we've been engaging with, because the final product that the members will see is an attempt that cohorted all of the parties that are supposed to be assisting in support of the committee. That includes the departmental advisors, the state law advisor, myself, and right at the end, Chairperson, we gave very limited time to Advocate Nell to also just cast her eyes on these issues. So, Chairperson, the draft A list does mention a number of sections that are proposed to be amended, and others that, as I will speak through, the members at the end will just have to guide us with the final position. For an example, Chairperson, the definition of bodybuilder, there was a number of discussions that were done, as well as emergency services. And finally, what we thought would be perhaps be the best as a suggestion is to have, because amongst others, but I will get into details when I go to that clause per clause, amongst others with the bodybuilder, it was an issues raised about whether the bodybuilder definition in the bill is not too narrow as compared to the one that appears in the regulation, and does it encapsulate all of the things that the public had pointed out through their submissions, as well as the responses that the department gave to assist the committee. So, Chairperson, we will be speaking to various clauses as under the definitions, and the most clear that we've taken through in the A list are changes that relate to instructor, local authority, motor vehicle, pedal cycle, as well as public road. The very detailed and very helpful submissions from Advocate Swanepoel did point out the implications, and therefore we've opted to take the one that is adumbrated in the judgment on the Mbele judgment by the courts, because that one we felt is the most inclusive and covers all scenarios and concerns that may arise. Hence, the law needs to bring certainty and clarity in terms of the position, as we have contradicting or contrasting judgments. Also, Chairperson, we are dealing with the issue which the members there are raised through the submission of Swanepoel as well, which was requesting that we make reference to the Criminal Procedure Act, which will indicate what happens to the impounded vehicles rather than leaving it open without any direction when legislation is supposed to be clear. Now, Chairperson, having said that, as we consider, there are possibly three methods we could have handled this process, Chairperson. The first one was to take the Principal Act and just insert through it so that members can run through easily with the process of understanding what was the Principal Act, as Advocate Nell was doing, what was the Principal Act's position, what are we proposing to change, and what other positions will be effected. The second method we could have used is to present a draft list which just is flighted to the members and speaks to everything that we thought we've been given an instruction to correct. Lastly, Chairperson, which is the option that I'm taking, and with your permission would appreciate to continue with it, is through the PowerPoint presentation to speak to the issues that will translate into the A list. And the last point I need to point for the members before we engage is that there are three places that are part of the bill and very crucial. That being, starting at the beginning, is the long title of the bill, which basically outlines the purpose and what it is that the attempted legislation seeks to bring about. And then right at the end of the bill is the memo on the objects of the bill, which generally provides clause by clause a summary what each provision seeks to undertake. And then it's also lastly, Chairperson, the arrangement of sections, which is generally known as the index. These three parts, Chairperson, have already been looked at and will be amended, but for their actual final part, because it's consequential, we have to do the final correction once the members have given us the final position in terms of each clause. Because as I said, it's consequential and you need to speak to each and every change in order to correct for purposes of people to know the history and what was finally the intention of the legislature. So these are the three most basic and salient features of the bill that normally can explain to a layperson what happened, why it happened, and how did we get to the conclusion that the final draft legislation becomes for the enactment by the president. Next slide, madam. Thank you, Chairperson. So without taking too much time, Chairperson, I will generally rush through these matters and just clarify under the definition and what clause is affected by that definition. So Chairperson, as I've already pointed out on the issue of bodybuilder, we will need clarity there as to whether we take the one that is on the regulation and therefore do not infect an amendment in the bill and take what is currently in the bill outside. Thus, it will be omitted and removed from the bill that will be passed by this committee. And then, Chairperson, the second issue is the issue, the bodybuilder question runs with clause 10, and what we will be basically providing once the, as I said, once the final position is taken. Amongst other matters, there was an issue raised by the submissions that any person in terms of giving this power to determine who is a bodybuilder will be very problematic. But then, as I said, we need to indicate whether we will go with the provision that is on the bill or discard that one and go with the detailed provision, which is more broader in the regulations. And then, Chairperson, in relation to the clauses that gave us a serious headache and serious submission from the public, as well as the committee, and appreciating the issues that are currently taking place in terms of foreign truck drivers, in terms of international driving permits. There was a lot that was said, Chairperson, and having looked at what the existing legislation gives us, it does define the driver, the driving license, international driving permit, professional driver, professional driving permit, as well as what the demands or the dictates of section 15, 23, and 32 currently are, which are basically general, the three main provisions that seeks to address that issue that was raised by the submissions and the deliberations of the members. And we were instructed that as the supporting team, especially the legal support team, the department, myself, and the state law advisor, we must give our serious attention to those three. So, Chairperson, when we get to those clauses and the suggested provisions, I will give the details. Another issue, Chairperson, within the definitions was the issue of ambulance as well as emergency services, Chairperson. The context of those ones and how they impact on the amendment is generally running out of clause 45, and clause 45 seeks to bring in a new insertion, which is a section 62A. The issue that raises, Chairperson, is the issue of mutual agreement or consensual understanding, and the responses of the department, and in light of what the submission, one of the submission in this regard was coming from the AA. They pointed out that they haven't had engagements to agree on this. But as when I get to the details, I will point out how this obligation is imposed on a private sector in light of the definition of incident that is proposed by the bill and what the actual 62A will then eventually achieve. And that's what the members raised, worried about. It's not clear who will incur the liability and be paying the services that will be rendered by the private sector if the legislation imposes on them that this is now a legal obligation that is imposed on them without them having mutually agreed or found consensus and then consensual direction to move forward, because we are guided by the public and the submissions that they gave us. And then the other one also, Chairperson, was section 65, which is amended by, I think, clause 46. This is the one that the general public was really, really giving more of the submissions, and that is the percentage on the alcohol that one can have in their bloodstream. So Chairperson, again, this one will impact, or whatever the position, and as the committee indicated, and we will point to it when we get there, it will impact on generally what Chapter 4 of the bill, Chapter 4 of the Principal Act is dealing with, which is generally how to be a proper and a fit driver that is licensed and permitted to drive in our public roads. And lastly, Chairperson, was the issue of Section 75, which runs with the issues that the members raised about the shareholders committee, as well as the other issues that already are in the Principal Act and are deemed as provisional or transitional sections that are trying to deal with the issues, keeping in mind that as this bill is a Section 76, it's because it deals with concurrent functional areas and powers that are given to both the competency of the national legislatures as well as the provincial legislatures. And if we look further, there are also other matters that impact on Schedule 5, which are the competences of the local authorities as we understand our constitution. Next slide, Madam. The other definition, Chairperson, which we have not effected on the A list, on the proposed draft A list, but are submitting a position that the committee must consider and then give us a direction whether eventually we really need to change what is already in the bill. The way bridge facility, there was a lot of submissions and discussions as well as we went through the process. But the issue that I think was standing out, unless I picked it incorrectly, and Advocate Nell assisted me on this one also to try and find my bearings, is the issue of whether we've excluded or not included the mobile way bridges facilities. If I looked at the current definition, Chairperson, and we understand the standing ordinary meaning of facility, I think generally we can safely argue that the definition is inclusive of both, whether it's a stationary facility or a mobile facility, as long as it does or seek to execute the function that is given for purposes of this exercise. Therefore, we are of the view, Chairperson, that what appears in 5E as a new insertion in the definition of the weighbridge facility is already inclusive of what the members were asking us to effect. Again, Chairperson, I just brought this point in for purposes of answering on the issue that relates to SANS, the standards, the national standards that we will need to deal with, especially in terms of microdots and it slips my mind what other provisions are related, but mainly on microdots, Chairperson, as well as the issue that I've spoken to about Section 62A, which extend the moral obligation when incidents are taking place. This Act, Road Traffic Management Corporation Act, it does as well gives another perspective and direction to the issues that were raised by the members, as well as what Section 777 of the Constitution provides, because that's where we derive the mandate that every creature of statute has, is in our supreme law of the Constitution, our supreme law, the Constitution, as well as then the legislation that is enacted and derived from those mandating provisions. So, Chairperson, this point is brought in to just bring guidance that the members need, as well as the context to say those provisions and the mutual agreements that needs to be consensual and done, where we force or impose on the public sector the issues as well as the involvement of the shareholder committee and how it's to assist and deal with the issues that are already there in place. This act is of great assistance, but it must not be read separately or away from the provisions of the National Road Traffic Act. Hence, all of them together, they become the various laws dealing with traffic matters. And then Chairperson, I think this one, section 31 and 32, on this act as well, is what I'm directing the members to perhaps look at and see whether, if at the end we really need to bring a provision that speaks to the concern related to clause 445 and the shareholders committee, read with 93A, will not be answering the concerns, but we are of the view that the concerns that were raised in respect of those three instances are already covered in our existing laws. Next slide. Generally now, Chairperson, I will just take you through the actual changes. I don't know if Advocate Nell perhaps can be able to flight both the A list and this one so that it's maybe easier. Normally she was able to do that for the members to hear what I'm saying, as well as see what the suggested provisions are there for.
Just give me a second. I'm just going to open your A list now.
Thank you, ma'am.
The 1 second has passed.
Chair, I have so many screens open. I'm going to share it now.
I was just saying the advocate has said 1 second. Thank you, advocate. Thank you.
Okay, Chairperson. I will just breeze through on what clause 1 will be dealing with. It's the issue of the bodybuilders, Chairperson, which should have been on top there, number 1, whether we are deleting it as it appears in the bill, or we then beef it up as already suggested by the submissions and the members' deliberations. It's emergency services with an issue only, Chairperson, on our suggestion, the issue of private body, because it will then read means emergency medical services provided by an organ of state or private body for private use, disaster management services, fire and emergency services, traffic officers, traffic warden, members of the South African Police Services, municipal police service, members of the South African National Defence Force, or the department responsible for health issues. The only outstanding issue, Chairperson, which we will need guidance is whether then, in light of what I've suggested and what the members raised, especially when it comes to the issues of incurring and imputing liability on private structures and 62A, are we going to be satisfied? Is the legislature going to be satisfied that that was properly covered in terms of including private bodies? But this also speaks to the issue of the doctors when they have to run on emergencies for their patients and use their private cars. So it's an issue that the members will just have to give us final guidance on. Then, Chairperson, what I've done with my bill. Chairperson, with your permission, my video is already off. I didn't indicate. May I just keep it off there, Chairperson? I wanted the manual copy of my bill so that I can explain also other things. Oh, I put it underneath the chair, Chairperson. I found it.
Okay, you can go ahead, ma'am.
Okay. So, Chairperson, on page 3 in line 45, it was also a submission that we got from the submissions, which with all the definitions, then these are consequential changes, and therefore it must come out, as well as on the issue of using Metropolitan Police Department in respect of defining emergency vehicles. So those have been cleared, Chairperson, and clarified, as well as a new definition for instructor. We've taken on board what the committee submitted, what the committee accepted, and the definition that appears there is the definition that we were asked to take, and it will read it as it outlines who are these people that will be dealing with instructors to assist people to be good drivers. Let's go down, madam, so that I see what is the next one.
Madlogov,
Yes, ma'am.
I want to suggest that where we need to get consent from the members, we should get it so
Yes,
that we do not overload issues. It may work out better. I want to suggest that let's deal with the bodybuilders and get the members to agree or amend and move to others.
Thank you, Chair. I'll accept that cue and I will pause here in.
Thank you very much for understanding. Honorable members, as we know, let me invite hands. Any suggestion, agreement, disagreement? Chambers.
Thank you, Chair. I think your intervention helped because that's what I was going to ask. We are seeing two screens, just for clarity, the one with the detail and the one that is on my right of the screen or the left of the screen. Is that the proposal? So that as we move on with your suggestion, we know what we are particularly looking at. So I thought I will seek that clarity also. So under the slide here, it says clause 1, it says bodybuilder and emergency, we still require final decision. But that's not what we are looking for. We are looking for what is the proposal, which I thought is where we were before the colleague moved back. Is there a proposal or is there a requirement for discussion? But I agree with you now. This is where we are at now. I would rather we look at what is the proposal. Where there is no proposal, there is a need for us to debate, then it must be highlighted. But I agree with you, Chair. And if I'm correct, we are looking at emergency services now, which I support that. If that clause 1 on my right is the proposal, I support.
There goes Honorable Manu is gone. Honorable Lunsinger.
Thank you, Chairperson. The definition in itself is difficult to consider if it's not within the context of the application. So what I mean is it's fine to look at the definition, but it might be that we will have to revisit all of the definitions once we get exposure to where it's applied within the Act, if that makes sense to you.
Okay, you're done. Let's try to check if Honorable Mangu is back.
Chair, I've been here all the time, unless I muted. I'd contributed to say I'm in support of the proposed emergency services definition. Having listened to my colleague, Honorable Hunsinger, I think that he has got a point to say maybe the definitions, in fact, could be affected by the context within which they are applied. And if that is carried through, maybe we need to move to the substantial clauses and finish off with the definitions, unless the team is able to take us between the substantive clause and what the definition says at the same time. But I agree with my colleague, Honorable Hunsinga there.
Thank you, Honorable Manu. Madlogov.
Thank you, Chairperson. I think with your permission and the direction that the members just presented now, it might be better to perhaps leave the clause 1 and just go to the content provisions, and then we come back to clause 1 once the members fully appreciate what we suggest in terms of context and the related provisions.
Let's do that, Madlogov.
Yeah, Bongabab. Alma, take me back to the presentation on the side of the bill, please. No. Leave the A list on this side, and then let's do the presentation on the other side. Thank you so much. Thank you, Chairperson. In respect of clause 2 and 3, Chairperson, those are the first content clauses, and clause 2 was the one that seeks to amend section 3A of the bill. And section 3A in the Principal Act, Chairperson, is dealing with the all sorts of traffic officers that may be appointed and given powers to work with us and make sure that we are good citizens on the road. But basically, Chairperson, what is then suggested in respect of clause 2 and clause 3, Chairperson, in respect of those officers, are the directions that we were given by the committee to add one that was missing, which was the reserve traffic warden, to ensure that they are covered in the enabling provision and the empowerment. And so that's generally in respect of clause 2. And jumping straight to clause 5, the issues that were raised for clause 4, Chairperson, and the submissions, we've noted that some of the submissions may have repeated what they brought to the department. So we didn't feel it necessary to once again repeat the changes because they are already effective. On clause 5, Chairperson, it's the same issue that relates to clause 2 to bring about the involvement of NATIS officer as well as the reserved traffic warden, which the amendment as well as the Principal Act had omitted, but the committee suggested that we give them the same clarity and powers as given by the others. Chairperson, on page 7, for purposes of this clause, in line 17, and amendment of section 3D, Chairperson. 3D, it's tightly in terms of the Principal Act. It deals with minimum requirements for registration. Minimum requirements for registration as inspector of license, examiner of vehicles, examiner for driver's license, and traffic officers. So, Chairperson, the qualifications that are set out in respect of those people, Chairperson, I think these are consequential changes in light of what the committee had already indicated, and the addition of these two structures or these two officers. Hence, the amendment that is in this clause is basically to make sure that that correction is effected and they are added as per the instruction. The issue of shareholder committee, Chairperson, I'll explain it. And in this instance, I think the state law advisor as well will have to come in and explain this one once I've dealt with generally what section 93A as well as the impact such provision is having on the bill. But if understood and we are together in terms of what we will be presenting to the committee, this is the issue where the shareholder committee and the minister on the converging powers and the powers that are overlapping is a matter we are trying to correct and clarify once clear what that provision is dealing with and who owns that specific power. Can we move on? And that's in relation to clause 5, Chairperson. So there wasn't much that was changed other than to deal with those structures. Clause 7, Chairperson, and under clause 6, we are not effecting any other changes, Chairperson, because when we deliberated with the members, the questions were on the may and the must, as well as the issue of off under 6DH, the examiner for driving. The other suggestion was suggesting that we do the off instead of having the for there. So those are just consequential and grammatical changes, but also on the issue of may, as we explained, and we appreciated that perhaps members understood the may in the context of giving the discretion, not necessarily that it imposes a compulsory duty that whatever appears there needs to be done or be enforced and imposed on those that might do it. So the mays that appear, and as we explained, are generally to enable the discretion and be able to look at what needs to be done and how it should be done, rather than be directive and enforcing when the process may have to depend on each circumstances. So what clause 7, Chairperson, if we move forward, does, which is an amendment that's effected. There was an issue, as I said, in respect of vehicles impounded when a traffic offense is being committed. The comments were suggesting that we are not speaking to what then will happen to the vehicle, and the submissions were suggesting that we give effect to the provisions of the Criminal Procedure Act. The suggestion was specific to the sections, but we thought it's better and more a good drafting style to just speak to the whole act, just in case there are other relevant provisions that if we list out, we may leave them out. Chairperson, on clause 8, I want to try and attempt to explain clause 8 together with clause 9. Clause 8, originally, it was substituting the existence of section 3L. And the existing section 3L, Chairperson, if we look at the Principal Act, it seeks to deal with approval of training centers. But that approval basically is telling the relevant functionary that the training center must be registered. So what we are doing in terms of the suggestion, Chairperson, and the issues that were raised, whether everything, the structure and the person is graded, what are the current compliance requirements and what appears in the legislation. So what we thought we need to do in terms of what the new insertions, which are 3M, 3N, 3O, and under clause 9, they speak to those concerns that were raised. And therefore, all we are doing in terms of clause 8 in order to correct and deal with the issue of the training centers is to clarify the topic, the title of that provision 3L, and then under clause 9, it then becomes in sync to speak to the issues and the new insertions. If you read the whole section in its entirety, 3L with the new provisions that they are bringing about in the bill itself already. So there is really not much that is being effected for purposes of clause 8 and clause 9. Clause 10, Chairperson, is an issue that deals with registration of manufacturers as well as the body builders under section 5 of the existing legislation. We were asked to ensure that so that we don't leave anything out, we make sure whatever is done there, it must be subjected to all the relevant traffic laws. And that's the suggestion that, that it seeks to provide there by saying there must be compliance with all the applicable traffic laws. We have not effected any changes on clause 11, Chairperson, as well as clause 12. Clause 11 is the introduction of how to handle the issue of blank number plates, the issue of microdots. So it's a new provision. But what we found, Chairperson, is that most of the submissions and the deliberations as we went through, at some of the issues that were already, like I said, with other provision, brought before the department. And when the bill came before introduction, they already effected the changes. Hence, we have not done any of the corrections unless the members feel we have left something in respect of clause 11, clause 12, as well as clause 13 in what they had instructed us to do. But it relates to the issues that when we go back to the definitions, the issue of microdots, the issue of bodybuilder, and the issue of weighbridge facilities in terms of giving the definition that eventually the committee agrees to and feels that it exactly captures the instructions and what we sought to achieve. Chairperson, clause 14 and clause 15 are the ones that the members deliberated a lot on, as well as ourselves when we were trying to find a way how to handle it. But just as a way of background, Chairperson, clause 8 was the original section 8 of the Principal Act, and section 8 in its original appearance, it was titled Application for Registration of Driving License Testing Center. So there were various issues that were raised in terms of a testing center. And what we have then suggested to capture all those changes and the repetition that the submissions and the members felt was done by the new insertion 8A and the existing section 8, because it's already there and it's already not saying much if we leave it there. We thought it's best as for drafting conventional standards to reject clause 14 and capture everything in line with what the memorandum of objects is saying under clause 15. And we are then under clause 15 adding all the other things that were left out and the submitters were saying we need to correct. So eventually what will appear in the Principal Act, should the members agree to this, it will be the amendment of clause 15, which seeks to capture both what clause 14 and clause 15 attempted to achieve. It can then, for easy reference of the Act and following the Act, be found all together under section 8A, which will be a new insertion, which is already part of the Act, but sort of took over what section 8 was already doing. So that is basically the cleanup and the correction we are suggesting, Chairperson, which aligns with the new definition of local authority that we brought into the definitions, as well as what the submitters had given us to say, and the members raised the issue of municipality and local authority. We are now defining local authority as all the municipalities found in the Constitution and defined how they are determined and established. So this is the best way we thought is best to explain and correct clause 14 and clause 15. I'm hoping it's making sense, Chairperson, because it's a bit of a muddled and convoluted matter that also gave us gray hairs. And moving forward, Chairperson, again on clause 16, it was an issue of shall, must, and may. It is basically grammatical use of the terms and the other ones outdating the other, but we haven't done any, because if we do the corrections, then we will have to revamp the whole act in terms of shall, must, but the meanings are still the same. Where shall appears or must appears, it's still mandatory and compulsory, but for developing English and preference, we better be using must moving forward instead of shall. And then on clause 17, Chairperson, I think this one I must clearly bring to the attention of the members. It does relate to the issue of the juristic, the definition of a person, which is inclusive of both juristic as well as the natural person being an individual person. But it also speaks to the issue that members would have followed with the news for allowing the appointment of a person, an authority or body. It's the correction that seeks to bring that clarity there, that when generally in law we speak to a person, we speak to both a juristic person and a natural person. So it's just a consequential correction that eventually will make the act more easier to read and understand. The same with clause 18. And clause 19, while it appears as clause rejected together with clause 20, it's because those provisions, Chairperson, that we're attempting to bring about the provisional license, in addition to the list that we know about a driver's license. And once you have passed your test as a learner, you then move to make the attempts being the proper driver. So because the members in our discussions, and they are pointing us to the end or the outcome, they indicated that as far as they are concerned, they are not persuaded to get the concept and understand what exactly would be achieved in the end. Hence, the effect of rejecting clause 19 and clause 20 will be to take out anything that relates to adding a provisional driving license in between a learner license and an actual license. So that's what is the impact of rejecting clause 19 and clause 20, is to deal with all the issues about a provisional license and all the insertions that are coming through. Yes, sir.
There was a bit of glitch, clear.
Oh, thank you, Chairperson. I'm sorry I couldn't pick that up, and my network is intact. Chairperson, I was saying in respect of clause 19 and clause 20, this relates to issues about the addition of a provisional license, which would have come in between a learner license and an actual driver's license once the person has gone through the test. So what the deliberations of the members pointed out is that they don't want to effect these changes in the Principal Act. Hence, that will be the impact of rejecting clause 19 and clause 20. It totally takes away the issue of the provisional license. And if the departments maybe intends to pursue it, I also pointed out that the provisions under section 14 as they stand does enable such in terms of regulations and directing what exactly was the concept that they intended to bring to the members. But the discussion of the members prompted us to come to the conclusion that whatever is being effected right now by clause 19 and 20 is not accepted. Hence, we are saying clause rejected in its totality as 19 and 20. In the amended bill, 1920 will not be part of the bill, and therefore there will be no changes to Section 13 and Section 14 of the Principal Act. We then move to Section 15, Chairperson, which deals with the disqualification. It deals with disqualification from obtaining or holding a learner's or driving license. That is under Clause 21, Chairperson. Generally, Chairperson, what appears in Clause 20, in Section 15, and Section 23 and Section 29 and Section 32 of the Principal Act relates to the issues that the members raised in respect of the SADC community as defined and understood, and what the bill defines to us as prescribed territories. But it also beginning to speak to the matters that were raised about the truck driver violence that is nationally on the roads and a concern for all of government. So what, Chairperson, we are proposing in terms of Section 15, which is under Clause 21, read together with Clause 23 and Clause 28, which amends Section 23, as well as I think it's Clause 38, which amends Section 32. What we are suggesting in terms of these three clauses, Chairperson, is to bring an answer or a suggested solution to what was the concern of the members, the concern of what is currently happening, and an enabling provision that can assist the minister to deal with the issues at hand that are impacting on the country as a whole, as well as our standing conventions, whether internationally as the bill defines it, or the conventions that we've agreed and rectified in terms of the SADC communities. Hence, Chairperson, what is the end result, especially under Clause 21, are the consequential changes that will assist us and assist the intention of the members as the legislators to then give effect to the changes that we would suggest for purposes of Section 23 and Section 32. This is an alignment, having taken on board everything that the members and the submissions suggested to us, Chairperson. These basically seem consequential. As I indicated, we are dealing with an existing legislation, hence members will be seeing omit and substitute and the underlines. It's basically the drafting standard, which we will, if need be, we will explain in details to the members. Clause 22, Chairperson, is the one that was saying people must take back their licenses if there are any changes, or if there's an upgrade, you're moving from a code 8 to another code. The members said they don't see the need of that, and therefore what exists currently, let it continue. Hence, Clause 22 will come out of the bill. There won't be any changes in terms of having to impose to people to take back their licenses. On Clause 24, Chairperson, this is the one that amends Section 27. Section 17, which I almost spoke to in another provision, and I said it's what the minister spoke to, and it was unrelated. But in this instance, Chairperson, this deals with the issue and the difficulties that we went through during the COVID time, that the bill, the act was generally restricting the application of having to be a proper driver and a permitted driver in terms of the act by applying in person. But now, with the suggestion of the department and bringing it to the members' attention also, with all the definitions that we've given around in person, it is to ask the members and bring it to their attention that the limited point where it was saying you can only apply in person. And in terms of moving with the times, you can now apply even online. So it's enabling an extent where technology must also be brought in place. Therefore, just that amendment will take away the application in person and allow both in person as well as online applications. And that is what clause 24 seeks to achieve by its amendment. Again, clause 27 was a consequential grammatical correction. A submission pointed out that on is not a good grammar word to use in the context of this provision. So we are omitting on and substituting from in respect of proclaiming and gazetting that specific part. On clause 28, Chairperson, this is now the one that I think the members may take time and consider. Clause 28 is the one that deals with section 23, which I'm saying it runs concurrently with it. We must try to read it under the context of chapter 4 of the Principal Act, and it speaks to the issues that were raised. And I think it was the suggestion from Swanepoel which spoke to how we can correct 23 and 15 and bring them all together in order to ensure that what were the issues is covered. And we take away the deeming provision, as the members pointed out that if you go to other countries, the deeming does not really happen, but you are enabled a specific period to just make sure that you comply with the laws of that specific country. So the suggested section 23 seeks to achieve exactly that, Chairperson, to take away the deeming provision, but ensure that when you seek a driving license, a driving permit, as a person from a prescribed territory, as a person from a foreign country, as a person from an international country and wanting to use your international permit, it's an enabling provision that says, ensure first that you comply with the conditions and the prescriptions of the country. And once that is done, because you must take personal responsibility and take yourself to the authorities, then you will get the proper authority in line with what the citizens are also doing. So it's an attempt, Chairperson, as we were asked, the state law advisor, the parliamentary advisor and the department, to try and see how then can be a solution to section 23 as well as section 32, which speaks to conventions and the deeming of international prescripts or international documents when it comes to driving in our public roads. So those are the suggestions, Chairperson. I don't know whether I should read it out or members can clearly read on their own and see what we were suggesting. But it aligns with what Swanepoel suggested, and we've just made sure that it corrects and covers everything. And again, straight to clause 37, it's exactly what I've explained, speaking to ensure that if any person who runs a business intends to employ somebody with international permits or foreign permits, without putting a risk and a responsibility on them, we were asked that they must not be given a power to say they must make sure that those people have these permits and they pay for them, but they must verify. Otherwise, don't just employ a person without having verified that they actually comply with the laws of the country and they are carrying the actual paperwork that is deemed and validated by the country of the laws, by the laws of the country. So that's what clause 37 and clause 28 are trying to do, Chairperson, in light of what we are suggesting. And then, Chairperson, clause 41, we effected a change there. There were not other changes that were done in the other sections in light of the deliberations of the members. But clause 41, Chairperson, is what we brought in after the deliberations of the members. as well as explaining that the in-person or any person is already a word that legally we have a definition. But what we do, because it was dealing with the delegation by the MEC, as well as any other delegations within the Act, we just wanted to ensure that even if we change the delegation to any person, because we appreciate that this is an overlapping function, as we've seen under the Constitution Schedules 4, as well as Schedule 5. But the power to regulate, as appears in Section 75 of the Principal Act, that's the only power, even if delegation happens by the MEC or delegations happens by the minister, it cannot be done because this is an ordinary power the legislature is restricting to only those that are mentioned. So the powers of Section 75 cannot and should not, in terms of the law and in terms of understanding the concept of delegation. And that is exactly what Clause 41 seeks to achieve. And quickly, Chairperson, as I've explained most of these things in my previous slides, what Clause 46 is then doing, quickly, Chairperson, on Clause 42, I think this is the one where we were asked to bring the list and add other agencies that may be necessary. The department will pitch in, but from our engagement, we thought that what already appears, Chairperson, is the only structure, the Passenger Rail Agency of South Africa, that what is sought to be achieved by this provision is addressing. So what appears already, we felt it's necessary, unless the department can bring in the list and assist in clarifying more, that it is not necessary to make any changes than what appears on Section 57, which is Clause 42. On Clause 43, Chairperson, we didn't effect any changes. And then moving straight to Clause 45 is the one that I explained, Chairperson, which brings in the responsibility of the private sector when there are incidents on the road. It's an issue of mutual consent, but because it's not achieved as per the submissions, we are only bringing a suggestion that, and in light of the deliberations, perhaps the members would want to consider Clause 45 by either rejecting Clause 45 as a new insertion, which 62A reads, in the event of a road accident, the emergency services shall immediately respond to the incident and render all the necessary services as prescribed. And the issue was on the definition of emergency services. And if we bring the private bodies, the issue still remains as members raised it. What will happen in respect of the fees? And this is not, it may be a moral obligation, but it's not a legal obligation that must be imposed on the private sector without clarity. So if the committee wants to legislate on this, all those issues that they themselves raised and the submitters raised must first be clarified so that when they don't comply, they know what they are not doing and what they need to do. So there is a provision that we need to add and deal with in respect of Clause 45, whether in light of the emergency services definition and what members will finally direct us on Clause 1 definitions, will we still need Clause 45, or it will have to be omitted and rejected as I've explained in the other clauses. Running straight to Clause 46, Chairperson, it was that one which was changing the alcohol concentration into 0. The members were very clear, no changes there, hence clause rejected. And again, in terms of Clause 47, this is where I had indicated I will explain in terms of the shareholder committee and the making of the regulations. Again, Chairperson, the members were clear in this instance, even after we had read Clause 93, Section 93A and how it impacts on the whole act as such, that Clause 47 no one wanted changes and they're taking out of the shareholder committee. Hence, there are no changes that will happen to section 75. And by saying clause rejected, both in 46 and 47, that means there won't be any changes in the existing sections as the public at large was actually indicating. So what is in place will remain in place. Clause 49 is basically, Chairperson, a consequential correction in terms of what the submitters pointed to the committee. Instead of speaking to the laws of any province, we were restricting it to only ordinances. But now that we know that this is an overlapping function, any prescribed requirements must be followed, whether it's a national law, it's a provincial law, it's a bylaw. That is what it will achieve by saying the prescribed requirements. And we are effecting that change in clause 49. In respect of, again, in clause 49, Chairperson, yeah, I think it's sufficient what I've said in terms of the correction that's effected. Clause 50, Chairperson, is a bit of an entangling tandem one, but it was dealing with the abnormal loads, vehicles on the road, and members had raised various issues in terms of who will determine what are the fees and why are we saying it's a may and the must in terms of giving that power to the minister and the MEC. What we are suggesting in terms of clause 50, then, Chairperson, is to attempt to address the issues that the committee had raised in respect of ensuring that it's clear. But then again, section 92 of the existing act also assists in terms of the issues about the fees and the determination, because when we read the amendment bill, we must never forget to read the principal act in its entirety as well, in terms of other matters that could already be covered and already clarified. Chairperson, winding towards the end, as I said, clause 53 is the one that will deal with the arrangement of sections, the index. This we will also effect the proper correction once all the consequential amendments and the proposed amendments by the committee are clear, and therefore the work on the amendment of arrangement of sections and the work on the long title and the work on the memo still needs to be finalized. That brings me to the end, Chairperson, of the presentation on the A list. I trust that I attempted to make it clear, because it wasn't an easy task, but it also because our bill is complicated. Thank you, Chairperson.
Madluguf. Siyabonga.
Ngiyabonga, Baba.
We're going back now in terms of our arrangement, am I correct? To deal with what we need to correct, amend, agree with. Right. Clause 1. So the proposal is on my right, where it is written clause 1, am I right?
Chair, if I can come in, just
Yeah.
before we get to the A list, which is here, clause 1, this is the A list, the new draft A list. We just need, per the slides that our parliamentary legal advisor indicated, and having made the discussion and highlighted some of the submissions regarding the definition of bodybuilder and the concerns around that. So for this one, we'll just need members' input, as she indicated, whether or not we're going to leave this in the bill as is proposed, or whether or not we're going to remove this and rely on what is in the Principal Act and the regulations to the Principal Act, because the submissions indicated that the regulations have a very more detailed definition of bodybuilder. It's not here in the Principal Act, but it's in the regulations. So, Chair, I think the legal advisors and maybe the department can indicate if we're going to move away from this proposed definition in the bill, is it more appropriate to have that definition in the regulations? And if they do it that way, is it because there might be more regular changes to what constitutes a bodybuilder for the purpose of building new bodies on chassis or chassis cabs or modifies motor vehicles? So, Chair, I think that was the one point where the legal advisor said we just need to get input from members, whether or not we're going to stick with the bill's definition or follow the submissions that say the definition in the regulations is more detailed.
You are saying in addition, Advocate Nell, that maybe we should test that with the department.
Chair, I think it would just give us a bit more guidance on, I know Chair normally likes to ask the question, would it hurt if it's in the bill? So if this is suitable versus the definition that's in the regulations, do we keep this definition? Do we insert the definition in the regulations, or do we leave it to be defined in the regulations alone, allowing for more regular amendments without needing to bring a new bill to Parliament every time to amend the definition? Chair, I think those are the three areas that perhaps the department can just give us a bit more clarity on.
Advocate, thank you very much. Advocate Mahatu, are you here?
Yes, I am, Chairperson, and good morning to everyone on this platform. Chairperson, from the deliberations that we held, Chairperson, I mean, from where we're sitting, one, I would agree with the submissions that the parliamentary legal advisor made, that the definition for bodybuilder as outlined in the regulation is far much more comprehensive enough, and thus making the one in the act more look like it's limiting. To that extent, the option would be perhaps, if at all, addressing the concern that Advocate Nell has raised, that it be moved up into the bill if the drafting conventions allow, or that it remains where it is within the regulations, and it addresses the issue that we've been discussing, and then it puts it to bed, so to speak. So yeah, that would be our submission or input in that regard, Chairperson, hoping that it assists. Thank you.
Thank you, Advocate. Let me invite members' views at this moment on this matter. I have 3 hands, or before I get to members, let me take Ms. Haricharen, then I'll take Honorable Manu, followed by Honorable Unsinger, or Lawrence McDonald, Honorable. You will be the third one. Ms. Haricharen.
Thank you, Chairperson. Chairperson, just with regards to the issue of definition of bodybuilder, this is a matter of legislative drafting practice. In terms of the amendment bill, this term bodybuilder is used throughout the bill. It's actually used in 20 places or so during the course of the bill. And for the sake of clarity of interpretation and for standard drafting practices, it's our view, subject to the department's approval, that the definition of bodybuilder be included in the amendment bill. Should the department decide as well to also elaborate on the definition of bodybuilder in future regulations, from our side, this shouldn't be a problem because the regulations do also have the force of law and are read together with the act. So then this should be fine as well. But it's our suggestion to the members that the definition of bodybuilder be included in the bill, in the definition section 1, as it's used throughout the bill. Thank you, Chair.
I thought we following the order.
Thank you, Chairperson. Well, the first thing I think Advocate Nell has put up, and I am assuming that's the definition within the regulations, which is more elaborate. My suggestion, without prolonging the matter, is that if the bodybuilder is kept in the regulations in the way it is there, we would rather take it in the way that it is formulated there and put it in the draft amendment bill or act, because there it is more specific. And I am of the view that this matter should be in the act rather than in the regulations, so that it could always give legislators a sight of it. And again, this is in the context of what we are dealing with in terms of the Public Protector's report, where many of the things that we see happened as a result of the looseness in this space. So my submission is that I propose, or rather we stick to it in the amendment, but we broaden it to be in exactly the same way it has been captured in the regulations. Thank you, Chair.
Baba Hunsinger, you were to follow.
Thank you, Chairperson. Chairperson, I am also convinced that this definition should be included in the bill itself, not the regulation. As such, it then gains a particular status as overarching reference, and it might be valuable for the improvement on legislation in this particular field. I'm comfortable with the content, the description, the elements which it's including and by implication excluding, and therefore I feel it is correctly positioned as proposed, and I therefore support it being part of the bill, not the regulation. Thank you, Chair.
Honorable
Chairperson, good morning, colleagues. Thank you, Chairperson. Good morning, colleagues. Chairperson, I'm in 100% support of both the previous speakers. Honorable Manu captured my thinking exactly the way I was going to respond, and I'm 100% covered, and I'm going to support Honorable Manu's suggestion, and I'll leave it at that. Thank you, Chairperson, for the.
Thank you very much. We're done with this one. The next one, Matlogov.
Chairperson, may Advocate Nell continue with this one as we move to emergency services, Chairperson.
Okay. Her voice is nice. Advocate.
It might be because I'm controlling the screen, Chair. Chair, this is the proposed expansion of emergency services. The definition is on this side for members here, as it is proposed in the bill. So that was what was proposed in the bill. And this is what is now proposed in the A list. So, Chair, I'm just going to read this one. It means emergency medical services provided by an organ of state or private body for private use, disaster management services, fire and emergency services, traffic officers, traffic warden, members of the South African Police Service, Municipal Police Service, members of the South African National Defence Force, or the department responsible for health services. Now, Chair, it's just important, as indicated by our legal advisor, the private body liability or private use liability, when we link it to the other clauses that were read, that require them to respond in all emergency services or all emergency situations. There may be a concern, as was raised in the submissions, about how do you force the private bodies, does it force the private bodies to respond in all situations, whether or not there is a memorandum of agreement with them and, let's say, the health services in the municipality or in the province, or for example, with Sunroll's medical services that they sometimes have. If Netcare 24 or the 911 guys or any of the other private ambulances are the closest to the scene and they respond, where or who do they claim their fees from if there isn't already a memorandum in place? So, Chair, this is where it gets a little bit difficult, because some of those service providers and the submissions, as I think it was the AA indicated by the legal advisor, made that submission that they were not consulted. If they are to be included, they were not consulted on this. So it may cause a concern from their side. If the bill is taken forward, they could say that there wasn't sufficient consultation with them, or there could be a dispute in terms of who covers the costs, because if they pick up somebody that doesn't have medical aid to cover the cost, where do they get the money from? Do they then have to claim it from the hospitals, or do they first need to have an agreement with the provincial Department of Health in order to claim these services back? So, Chair, that is the little bit of a ball in the air, or a stumbling block that we have to deal with in terms of this one before we agree on the definition, Chair. I hope the legal advisors and state law advisor can just jump in if I didn't clarify this sufficiently to raise their concerns.
State law advisors, I don't see them. It means they are covered.
Yes, Chair. Sorry, Chair, we are here. We are covered. Thank you, Chair.
Honorable Manu, followed by Honorable Onsinger.
Thank you very much, Chair. Thank you, Advocate, for that explanation. I don't see a problem here, Chair, because here we are not dealing with issues of claiming, because there would not be any claim, in my view at least, that would arise as implication or consequence of a National Road Traffic Act once amended. Here we are dealing with an issue of defining, once you are using a public road, in terms of this emergency services, who is defined there? I'm not sure why we want to interpret or try and understand who would claim from where and how and all those agreements. While I'm not saying they're not important at all, but I'm saying as it relates to the bill before us, I'm really struggling to understand its relevance thereof. Maybe that clarification could assist me. But if I'm correct, then this current proposed emergency services draft, in my view, suffices. Thank you, Chair.
Honorable Onsinger.
Thank you, Chairperson. Chairperson, I think we sit with a classic example of two opposing sets of value. The one moral in nature and the other one legal in nature. I think the need for this particular description leans over towards a civic responsibility, and therefore to cut a short line directly to this particular debate, if any involvement is subject and necessitates additional agreements, they should be in place. And therefore, the moral obligation to act to a particular emergency cannot be overruled by an arrangement of payment. The obligation to save a life to me stands. And therefore, this is how far our objective and our assignment is in terms of putting detail into this act. And therefore, Chairperson, whatever agreements is necessary to get paid, I would submit that that would be responsibility of the particular service in relation to the area where it functions, in relation to the particular paying stakeholder. And therefore, Chairperson, I want to submit that it's fine in the current description and we should accept it as is. Thank you, Chair.
Any member who has a different view must raise their hand now, otherwise they must keep their peace. Going once. Thank you very much. Advocate. That was voortgaan.
Thank you, Chair. Then just here at line 45, the new A-list just suggests the removal of emergency here in the description of emergency vehicle. That is this number 2 that they are proposing there. So then it would read, means a firefighting vehicle, firefighting response vehicle, rescue vehicle, ambulance, medical response vehicle, a vehicle driven by a traffic officer, and so forth. Chair, I think this is also to address some of the concerns that members raised regarding what, whether or not, if we just say emergency vehicle or emergency medical response vehicle, will it also cover doctors that have to affix a light on the car to respond to a situation? So I think that if we say that it is a medical response vehicle, that should allow for those purposes as well. Chair, then on line 49 here is to omit the Metropolitan Police Department, or because if we refer to municipal police service, municipals will cover all spectrums of the three. It'll be the district, the local, and the metro. So by using just municipal police services, that should be covered. Otherwise, it's a bit of a duplication here, Chair, or you have to also specify the other types of services. So that one just makes the emergency vehicle, or those two make the emergency vehicle definition a bit clearer and more in line. Then, Chair, before I get to instructor, I hope that those two additional proposals are fine for members.
Let me not assume. Let me check if there's any hand that seeks to say there's something. In the case of no hand, I take it that it is fine. Going once. Thank you, Advocate. Let's forge ahead.
Thank you, Chair. Then here in the bill, members would have seen the instructor definition was very short, but in the deliberations and based on the presentation received from the department as well as Ms. Swanepoel, and in all the members' discussions, members did indicate that they preferred the proposed definition that Ms. Swanepoel gave. So the definition for instructor, clearing it up here in the definition is also better than trying to clear it up in the clauses. That was one of the concerns. Otherwise, you had to go to section 28B every time to see instructor. So now we have a nice instructor definition. So the new proposed definition, instructor means any person who, for direct or indirect reward, A, instructs any other person in the driving of a motor vehicle, B, teaches any other person the rules of the road traffic signs, or any other teaching in order to obtain a learner's license, a driving license, or a professional driving permit. So that is the proposed new definition for instructor, just to get members feel if they are happy with that definition.
Honorable members, any view? Can we move? Is everything okay? Advocate, let's forge ahead.
Thank you, Chairperson. So members would have seen here the bill went from I to M, so there was no previous definition of a local authority. But we received quite a few submissions and members' input on the need to have the definition for local authority. And then that also followed with the various consequential amendments that was indicated by the legal advisors throughout the Act. So with the insertion of the new definition for local authority would read as follows: means all municipalities conferred with the powers of the local sphere of government as envisioned in Chapter 7 of the Constitution. So, Chair, that is a new definition for the bill. Before I move on, Chair, if members are happy with local authority, I'm moving on to motor vehicle.
Just a moment, just a advocate. Can I see hands, honorable members, or you want us to change the modus operandi? I don't see hands here.
Chair, on my side, every time there is happiness, I put in that thumbs up. Maybe Chair doesn't see it, so as to save time. But if there is a debate, one would raise the hands. Thank you, Chair.
Thank you, Honorable Member. Babu Keta Maban. Mondis, you happy?
Thank you, Honorable Chairperson. Honorable Chairperson, first of all, yes, Honorable Chair, you hear me?
Yeah, I can hear you loud and clear.
Thank you, Honorable Chairperson. I have a problem of network. It always take me out because there's a lot of things that I was to make a follow-up, but I don't know, have you passed the section 3D?
Advocate?
Chair, our parliamentary legal advisor went through those definitions, but currently we, through the clauses, but currently we at the definitions, so we are still going to get to that clause that amends 3D, Chair.
Thank you very much. You have yet, Honorable Mondisa, can you lower your hand?
Okay,
please.
Chair.
Thank you very much. Just remember when we are there. Advocate, can we forge ahead?
Thank you, Chair. Okay, so we have a new proposed definition for motor vehicle. This was also from the submissions and members' view in the deliberations that the proposed definition that was brought from Ms. Swanepoel's side was preferred. So this is what the bill proposed here on this side. And this is what the new definition will look like. Motor vehicle means any self-propelled vehicle and includes a trailer, and B, a power-assisted pedal cycle, except for power-assisted pedal cycle contemplated in subparagraph 3, but does not include Roman 1, any vehicle propelled by electric power derived from storage batteries and which is controlled by a pedestrian. Roman 2, any vehicle with a mass not exceeding 230 kilograms and specifically designed and constructed, but not merely adapted for the use of any person suffering from some physical defect or disability and used solely by such person. Roman 3, a power-assisted pedal cycle having pedals and an engine or electrical motor as an integral part thereof with a maximum mass of 30 kilograms and a design speed not exceeding 25 kilometers an hour that complies with the prescribed requirements for power-assisted pedal cycles. Or Roman 4, a vehicle that has maximum design speed of 45 kilometers an hour that complies with the prescribed requirements for environmentally friendly vehicles. So, Chair, this new proposed definition is also in line with the non-motorized transport policies and the provisions that provinces also use when they look at the road construction to make sure that it allows for non-motorized transport as well as your motor vehicles. Chair, it's also very important that this definition of motor vehicle covers or is in line. I'm sure that the advisors had a look, that it's in line with road accident fund legislation, or that the road accident fund will then in turn just refer to the definition of a motor vehicle in the National Road Traffic Act for purposes of claims against the road accident fund. Chair, that is the proposed new definition for motor vehicle for members' consideration.
Thank you, Advocate. Members are indicating that we can forge ahead. Thank you, Honorable Unsinga and other members. Let's continue.
So, Chair, also flowing out of the inclusion of pedal cycles in this definition of motor vehicle and in the clauses that will follow a little bit later, it therefore requires us to have a sufficient definition for pedal cycle. So members will see here, this reference in the Bill's definition to the weight and the speed has now already been covered in the motor vehicle definition. So we propose a new definition for pedal cycle as agreed to in the deliberations by members to follow the proposal from Ms. Swanepoel. Pedal cycle means a bicycle or tricycle designed for propulsion solely by means of human power, or B, a power-assisted pedal cycle as contemplated in subparagraph Roman 3 of the definition of motor vehicle. So, Chair, it's already in the motor vehicle definition, therefore we don't have to repeat it here. So that is just to be in a better drafting style, Chair, as well. If members are happy with that one, then we can go to public road.
Thank you, Advocate. Let's forge ahead. Thank you. Members are happy. Thanks.
Thank you, Chairperson. Public road definition. There wasn't one proposed in the bill. I'm just going to get back to the Act's definitions here for members. Okay, let's go to the Act. And there is, I'm quickly just going to flag it to members because it's now, okay, let me do this. There we go. And we can all see everything. So this is the public road definition that is currently in the Act. Members will see it's a lot shorter than the new proposed one, but the new proposed one I think covers all the concerns raised on the definition. So the new proposed definition will read, public road means any road, street, or thoroughfare, or any other place, whether a thoroughfare or not, which is A, commonly used by the public or any section thereof, or B, the public or any section thereof has a right of access and includes, Roman 1, the verge of any such road, street, or thoroughfare. 2, any bridge, ferry, or drift traversed by any such roads, street, or thoroughfare. And 3, any other work or object forming part of or connected with or belonging to such road, street, or thoroughfare, and includes roads inside a residential estate or any other area with the prescribed methods of access control. Chair, this one again, this is very important.
Apologies, Advocate Nell, I accidentally muted you.
Thank you, Valerie. I saw you were muting me. Just when I want to tell members that the definition of public road is also important for road accident claims. It's also important, there's quite a bit of litigation on who controls or maintains speed or road signs in residential areas, especially where there is boom gates or estates or access control methods. So this will then cover all of those issues and bring it in line with some of the case law that we've seen, as the legal advisor mentioned, that expanded the definition of a public road. So, Chair, that is the new proposed definition for public road for members' input and consideration.
Thank you, Advocate. Members are happy. Advocate.
Thank you, Chair. Then just moving to clause 2. So members will see here, this is an addition to page 6, line 15. So after this, we will insert reserve traffic warden. This was based on the deliberations from members, so that we do also cover the reserve traffic wardens here, because we did also include the notice officers. And then on page 6, line 20, to omit sub-paragraph and just substitute it with sub-paragraphs. So, Chair, that is just to make sure that the grammar is correct and to make sure that it does cover the additional paragraphs that have to go in there. Chair, that is the proposed additions to clause 2.
Let me see happiness from members. Advocate, there is no question. I see a hand that say happy. Thank you.
Thank you, Chair. As indicated by our legal advisors, clause 2 and 3 are basically the same. So there was no further additions proposed to clause 3. Clause 4, that one in our notes through the discussions, there was some clarity seeking questions on the spouse or partner issues, but that was addressed with the department in the meetings and the presentations. So there's no new additions to clause 4 proposed. Then in getting to clause 5, again, this one also makes sure that we include the notice officer, as members indicated during the deliberations, because 2 and 3 have those included. It follows through that it should also be included in clause 5. So we've amended the heading to now also have the reserve traffic wardens and notice officer included in there. And then also the addition here in line 12, after officer, to insert here a reserve traffic warden or a traffic warden, as indicated here in the bill. Just make sure that we cover all those additions. And then Chair, here in line 12, it's to remove the or, and then after warden to insert or notice officer. So it's going to be traffic officer, reserve traffic warden, comma, a traffic warden, or notice officer. And then Chair, down here in CA, this is the 3D that Mr. Sitole was asking about. This is the section that affects 3D. And here the proposal is to omit in this line shareholders committee and to substitute this with minister. And as indicated by our legal advisors, Chair, that was because of section 93A that the department indicated in the discussions. If I pull 93A up, it's that clause that says the phrases and the words are really used interchangeable with each other. I just want to refresh members' memory. There we go. It's part of the transitional provisions. So members will see sections 3A to 3E, so it'll fall under 93AA. Any reference to the Chief Executive Officer or the Inspectorate of Driving License Testing Centers or the Inspectorate of Testing Stations shall be regarded to be reference to the MEC concerned. And then here also for B, section 3, 1 and 2, any reference to shareholders committee shall in consultation with the relevant MEC shall be regarded to be reference to the MEC concerned, and any reference to shareholders committee shall be regarded to be reference to the MEC concerned. I just want to see further down here, Chair. So, Chair, what it might need is just to make sure that the reference here that they have, for example, in 51A, any reference to shareholders committee shall be regarded to be a reference to minister. It should apply the same to here. I'm not sure if this is going to require a consequential amendment later on to 93 capital A, or if these provisions are fine. I think the legal advisors can just indicate whether they are happy that it covers that indication from the department that these are either or, so you can substitute minister here, or if members feel that we should not remove the minister and keep it as it is proposed in the bill, then members can indicate same, because if we keep it the way it is in the bill, it will read, has obtained an appropriate qualification at a training center approved by the shareholders committee. But members, this is again, you have to link it up with the sections in the bill and the act that referred to training qualifications for these officials, for the wardens and the examiners. If in the clause that speaks to the training, it refers to the minister, then this should be changed to the minister. I think our legal advisors can just clarify that one for clause 5, Chair.
Madhugov. Legal advisors, where are you?
Thank you, Chairperson. This one will be for Ms. Hari Kashan, Chairperson, with your permission, please.
Ms. Hari Charan.
Thank you, Chairperson. Chairperson, with regards to clause 5, it was, as mentioned by content advisor, to provide for provision for the notice officer and the reserve traffic warden. And in relation to, as she's mentioned, section 93 of the Act, does refer to the shareholders committee and the MEC and the interchangeability of the usage of those terms. It is already provided for in the Act. And basically, in terms of the A list, the proposed amendments are to provide for on page 7 for the inclusion of the reserve traffic warden and the NATIS officer. Thank you, Chairperson.
Thank you very much. Let me hope that that is clear. There is a hand from Uchambas. Ungena Chambas. Ungena Mondis.
Thank you, Chair. Thank you, Chair. Maybe if Ms. Haricharan will help us when she contributes again, speak closer to her mic, because we could hardly make, at least I could hardly make what she was saying. Chair, my contribution is in number 6, which seeks to omit the shareholders committee and substitute with the minister, and all such references in this particular piece of draft in front of us. Chair, my view is that, as I've said before, the intention of the shareholders committee is very clear in terms of the RTMC Act. What seems to appear here is that maybe, this is my assumption, there is frustration in getting the shareholders committee to do what it's supposed to do. And now there is now an attempt to get back those powers to the minister. I think, Chairperson, it is something that will not really fly. Even in my view, it will not pass constitutional muster, because, at least in my view, some of these functions referred to here are functions that should be performed at another sphere of government, if it is not through the shareholders committee. I therefore submit, Chair, that only on clause 6, as I said, that is where my comments are. I'm in agreement with the others that we do not accept the replacement of the shareholders committee with the minister, and we keep the shareholders committee at the center. Thank you, Chair.
Chambers. Mondis.
Thank you, Honorable Chairperson. Honorable Chairperson, I think Honorable Mangu have taken what I was actually want to say, because actually from my side, it is very difficult when you are saying we have to omit the shareholders committee, because we are talking about the shareholders here. So how can the shareholders can be substituted by the minister? Because there's a lot of event that is going to be done by the minister. But if you are now taking the shareholders, it means now we are giving the shareholders nothing that they have to say in this bill. Thank you very much, Chairperson.
Mhlakazi. Honorable Onsinga.
Chairperson, I think there is particular benefit in the current design, also in terms of role and function, but particularly in the sense of necessary check and balances. Therefore, I concur and feel that it should stay as it is. It should not be changed. There's also a particular contestability issue that might arise in neutralizing the shareholders committee, and therefore I propose that we maintain the current structure and design for its benefits. And since a balance in check and balances is rather necessary, so therefore, Chairperson, I agree that we keep it as.
Thank you very much. honorable members, this brings us to the pause on item number 1. As I promised you that I am reliable, at 11 o'clock, I will want us to switch to item number 2. We shall continue with item number 1 as we move on. Am I correct, Valerie?
It's 11 hours.
Chair, the discussions, deliberations on the A list is set for 2 meetings, today and next week.
Thank you very much. Now we get into deliberations on the economy, regulation of transport bill. That is bill number 1 of 2020. The department presented last week, and the members has to have their consideration in terms of the presentation by the department, whether we agree with the presentation of the department or we have our own views. Advocate Nell, are you going to assist that process? Let me allow you formally to do so.
Yes, Chair. I just want to get this one up on the screen. That's the one we need. Okay. Members will recall the department did this presentation last week. I'm going to try and make sure that it's a little bit bigger for all our eyes. There we go. So, Chair, what I proposed to my colleagues last week is that we give members the chance to look at the matrix again, because last week we ran out of time to get members' input on this. Chair, and then members can see this, for example, is for the definition to access. And if we look at the bill, just want to get that definition out. Okay, there's a very short definition there. But here, the suggestion was to add a user to access, and then members will see here that the department indicated here that there might be some difficulties if you want to tailor make it to the specific mode or industry. And the department therefore did not agree to this proposed change. So Chair, I just want to see from yourself or get a feel from members, if we run through the matrix, it is quite a few pages and it did take a lot of time last week. Would members like me to focus on only the responses where the department agreed to the proposed changes, or should I take members through them as they are here line by line? I just need to make sure that we get a running process for this so that we can get to our next A list for the ERT, but we need to go through this process so that we can get our drafters to have a clear view on members' input to the new A list. Members will recall this one was the one that we advertised for additional comments. That was the A list, especially these points marked in blue. They were the new amendments that were not in the bill that we received from the submissions as well as the deliberations. So that's one is just to refresh members. That was the old A list. We need to add to this A list now based on these responses from the department. So Chair, if you can just give me a bit of a guidance here. If I'm okay to continue line by line, I am ready to do that, Chair.
I can see you're putting a time factor here, advocate. What's the difference, if I may ask you?
Chair, I think if members in listening to last week, if I can get a feel from members, were they amenable to the department's agreements to those changes? Rather, because if we have to go to it line by line, we can do that. It'll just take longer, Chair. We might have to then continue with this also in our next meeting on the ERT. But if, for example, I go to this one on definitions for number 6 of the A list, where the department agreed to the observation to be revised, then I can look at those ones and we can try and work on just the ones that the department have already agreed to. But I just need some help from members, because they could have had questions last week that they noted down. And if the department is here, perhaps the department can clarify on the questions, or we're going to clarify as we carry on, Chair.
Honorable Hunsinger.
Thank you, Chairperson Zwane. Chairperson, I'm of the opinion that currently we have a very fragmented, yes, not perception so much, but a fragmented structure in terms of these many variances of content. And it would really help, although it might take longer, but it would really help to go through this item by item, just to structure and refresh at where we are now, because very useful additional information have been submitted, which proved the public participation round to be worthwhile and credible. So, Chairperson, my proposal then would be that we, although it takes longer, that we do go through this item by item. Just to give you an example, around the first definition, access, I'm of the opinion that it should not be defined at all, but that access is a condition defined in agreements, and therefore access agreement should be defined, but not necessarily access, so that we don't have to struggle with whether users should be included opposed to only having access. So I'm sure other members have other reasons for going through item by item, but it would refresh our mindset and also direction, since I'm of the opinion that it's rather fragmented at this stage. Thank you, Chair.
Thank you, Honorable Hunsinger. Jambas.
Indolently, Manget. Chair, mine, at the end, I think I do agree with my colleague, Honorable Hunsinger, in terms of going line by line. My reference to Indolentlela is really to say, I think we should be patient and make sure that once we are done with this, we are happy that we have given it our best. However, my approach would be rather in going line by line, our emphasis should be where the department does not agree, because that is where I believe our role as public representatives comes in, to protect the interests of the public and understand why the department doesn't agree and take a view from there. Where the department agrees, I think it will be very limited occasions where we oppose that, although we can do that. I think that will also emphasize the fact that we do take the input by the public which we asked for a second round to make comments on this very important piece of legislation. Therefore, Chair, I think it will be painful, it will be long, but I think it's part of what we've signed up to. Let us take it line by line. My amendment, slightly, if agreed, is that we concentrate on where the department has gotten a disagreement or where honorable colleagues have got a particular interest or note they've picked up. Thank you, Chair.
Hallelujah, Mfundisi. Mondis.
Honorable Chairperson, no, I do agree with two honorable members, because if you say line by line, but the first thing that I'm trying to check, Chairperson, if we do agree that we go on line by line, I'm trying to check the difference between the access and the user. What is the difference between these two? Because I know that if you say we have to have an access, you can on different infrastructure or facilities. But I'm trying to check, why do you want to use the user if that one can be defined, Chairperson? Thank you very much.
We'll get into those details. Thank you, Mondise. Nademekis.
Honorable Chair.
I see your hand is up.
With respect, Chair, I want to add another confusion item that will probably help to deal with the better of the approach that I think you are trying to resolve here, Chair, if I may.
Yes.
There's one point of clarity that we seek from the Department of Transport. When the publication was done for the second time, there's a different understanding from the department that the focus of the comments should have been in the main on the A list. I'm subject to correction, but I have an urge to raise this matter, Chair, so that you give guidance and clarity as to how we move forward. Because most of the comments which are highlighted black, vis-a-vis those highlighted blue, the ones which are black are basically on the bill itself, Chair, which is the bill that was advertised for comments when it was introduced to Parliament. And the comments which are highlighted blue are those reflected in the, or we're focusing on the A list, Chair. So we are grappling with the approach as well from the department's point of view in terms of this next step of the portfolio committee. Should it be really on the totality of the comments, which would be on the bill itself and be on the A list, or should the comments themselves be focusing on the A list, Chair? I think that's a matter that we are grappling with. I thought maybe it's best that I raise it now that there's a discussion around the best approach of dealing with this matter, Chair. It's just to share more information for the portfolio committee to consider as well. Thanks, Chair.
Thank you very much. That make it Skudo. If you lower your hand. Honorable May, I can see you are in the house. Was your hand up?
No, Chairperson. Thank you.
Okay, you are just greeting. Thank you very much for greeting. I see that there are comments from different organizations which are here now. I want to believe that members are correct in this instance. That let's go line by line. If there is a line where we want to get some clarity, let's get clarity and move on, clean up and be structured. That's what I'm hearing, and I incline to agree with. And in that note, Advocate, we have given you now a direction. Although longer, I'm not gonna say it's painful. I will say it serves us correctly as a committee to do a thorough job. Advocate?
Thank you, Chairperson. Chair, I think just on the concern raised by Mr. Sitole for why this body suggested the use of user instead of access, the department did indicate in their presentation that this is a term, the term user really is a term that they use in the aviation industry. And because this bill seeks to look at the economic regulation through different modes, because the focus is on transport, if we change access to user, then we're basically changing the definition to suit the aviation sector, and it might not suit the other sectors where the reference is more in line with access. So this, from what I understood, that is why the department indicated that they would still be happy with keeping access in the way that it was in the bill, because if we look here at the A list that we did, there wasn't a amendment to access during the previous deliberations. But in the bill, access is there. It means the use of infrastructure, a facility, or a resource by an access seeker to provide goods or services to customers of that access seeker. And that will flow into access agreement. But that access agreement is the next one where the comment comes in. Again, here from the aviation sector, they normally would use user agreements instead of access agreements. So that is why the department indicated that for these two, for these comments coming from the aviation sector, they believe that the way that access was described in the bill is sufficient, because we can't just legislate for one mode or specific to the aviation sector. And then if we look here at the Western Cape's input on access, they say it should be extended to provide for other types of access seekers, not only those who provide goods or services. So this is from another angle. So they would like that definition to be revised. And then the department indicated here that the intention of the definition in the bill focuses on infrastructure and facilities which are catalysts for access of movement of goods and people. They do not agree with the change in definition. So Chair, that is the proposals on the term of access and access agreement from this first page of the comments. And I'm just going to put the bill up for members so members can see those two definitions, and then the members can give their input on those first three lines, Chair.
Advocate. Hello.
Chair, I see there's a hand of one of the members up.
Yes, thank you very much. Chambers.
Chair, thank you very much. Thank you, Advocate. I move that we retain the proposed definition of access agreement as proposed by the department. I'm of the view that the aviation one is clear. However, the one from the Western Cape, they do not suggest anything, therefore making it difficult for us to see whether there would be a need to go beyond that. I move that we accept it in the way it is, Chair. Thank you.
Any different view or is Mondisa?
Thank you, Chairperson. I agree with Honorable Mang. Thank you.
Thank you. Any different view going once? Thank you very much. Let's move, Advocate.
Thank you, Chair. Then members will see here, Western Cape, Department of Transport and Public Works, indicates for one of our proposed definition changes. So members will see here, it was number 6 of the A list. Oh, that's very big. There we go, a little bit better. So there's number 6. It's a road transport to add an infrastructure. Term infrastructure should be clarified. Furthermore, it's assumed that the intention was to state in line 61 and not after line 61. And the department said here they are in agreement with the observation. So they are suggesting that after reference changes to in line 61, not after line 61. But on the clarity regarding infrastructure requested here by the Western Cape Department, I just want to go down and see if the department addressed it there. Oh, that's the next comment. So Chair, perhaps let me do the poll. Let's see if we have a definition for infrastructure. We don't have one there. If we look at the A list, we just have a change here of an infrastructural resource owner. So Chair, I see the state law advisor has a hand up, so perhaps she can assist here for members. But if members have any queries or if they are happy to agree with the department on this amendment, then we can just get members' input for this proposal here from the Western Cape Department, Chair.
Thank you, Advocate. Mayor Raksha Haricharan.
Thank you, Chairperson. Chairperson, just with regards to the definition of the term infrastructure and the comment by the Western Cape Department, Chairperson, we humbly are not in agreement with the Department of Transport's response in regard to that comment, purely on the basis of legislative drafting practices and a matter of correct drafting style. The definition of infrastructure is going to be included in the bill after the definition of transport sector as it stands at the moment. If one takes a look at the current version of the bill, in line 61, it cites line 61 includes the definition of transport sector, means shipping and ports, aviation, rail, and road transport. And it's the intention to include the definition of infrastructure thereafter. Yes, so we believe that it should remain as after line 61. Thank you, Chair.
Thank you very much, Ms. Haricharan. As you lower your hand, Chambers.
Yeah, Chair, I battled again to hear Ms. Haricharan there, but what I wanted to check, because I'm also inclined not to understand what the department is agreeing to. except the after, which is before. I think that one makes sense. But I wanted to understand, are we saying, therefore, if you could go back, advocate, to the proposal as it is now, so that I can read it in the way that I understand it and make my concrete recommendation? Thank you very much. Are we suggesting, therefore, that we remove after the comma on page 7, that one, and say in line? That is my first clarity. And therefore, within the inverted commas, the proposal is that we say after road transport to add infrastructure, which would read road transport infrastructure. Is that my understanding? Chair, as a clarity seeking question. Thank you, Chair.
I wish to implore Ms. Harcharan's generosity to try and raise her voice. I thought I was following so that we don't miss the input she has just made. Mayor Harcharan?
Yes, Chairperson, I will do that. I apologize about that. I'm just connecting via my cell phone. Yes, Chair, just to reiterate what I mentioned previously, if the members, if I may refer the committee to the definition of transport sector, in the present form of the bill, it is included in line 61 of the bill. Transport sector, if I may read, transport sector means shipping and ports, aviation, rail or road transport. And in terms of the proposed amendments in the A list, it is also to include the word infrastructure. In the current form of the bill, the word infrastructure will be included after line 61. If one looks at the bill, the word transport appears at the end of line 61. So as a matter of technicality and drafting style and inclusion of a word, it would be in the next line. So technically it would be after line 61. But however, we yes, that's what we feel for our rationale behind the proposed amendment, Chair. Thank you.
Jambas umthole kahle.
Mangena ngimthole kahle.
Ngiyabonga.
Thank you very much, Ms. Harcharan. And I therefore agree with her that we do not accept that recommendation that the department is accepting. Thank you, Chair. I think it makes a lot of sense. We continue in that line. That is my concrete proposition. Thank you, Chair.
Thank you very much. And the delegates is good.
Honorable Chair, ke kopa ho thusa nyana mona. Okay, thank you, Chair, for the opportunity. The explanation of the state law advisor, it is clear to me. It's on the basis of the fact that there will be an inclusion of an infrastructure definition, which therefore means the line 61, the after line 61 matter will settle as such. But I want to check with if indeed did we agree on a specific definition for infrastructure, because my understanding is that we've been using infrastructure and facility interchangeably. So maybe she might help me to understand as to what definition did we agree upon on infrastructure, Chair, because the matter as it stands after line 61 with her explanation on the basis that there would be a definition of there will be an inclusion of a definition of infrastructure will suffice. However, I would want to understand what is that definition so that we know what does it mean, because if it does not appear in the A list, how would that decision be considered by the committee going forward, Chair? Thank you.
Mayor Harcharan.
Thank you, Chairperson. Chairperson, if I may refer the members and the department to the previous deliberations on the bill, after the first round of, after the bill was published in the first round of public submissions, during the deliberations, the issue of the term infrastructure was discussed at length by the members. And it was mentioned at that stage that the term infrastructure was not included in the bill. In the definition section, in section 1, there is no definition for the term infrastructure as it stands. And if I may refer members to page 9 of the bill, the introduced bill, in line 41, that is, it starts with chapter 2, and then line 42 is the heading for chapter 2, stating access to rail infrastructure. And the discussions in the previous deliberations, if I recall correctly, revolved around the heading access to rail infrastructure, because the term infrastructure was being used in the bill in line 42 on page 9 of the bill. However, there was no definition of infrastructure in the bill. And this proposed amendment in the A list was done in order to address this concern of the members, to provide for the term infrastructure, and was, if I'm not mistaken, was agreed to by the members to include the term infrastructure into the term transport sector in section 1, to comprehensively provide for the use of the term infrastructure in chapter 2, and the reference to access to rail infrastructure. Thank you, Chair.
Thank you. That settles this debate. Move forward. Advocate.
Thank you, Chair. Okay, next one speaks to clause 4 of the A list. Okay, let's go here. So we skip clause 2. Here we go, clause 4. This is that new clause that allows for the phased-in approach of different regulators as this regulator finds its feet, and it can include other entities. So that's just a quick refresher for members. And then going to the comments. Members will see here, this is the Western Cape's input. Inclusion of regulators should follow a process of consultation. It's unclear what grounds the minister may use to determine what regulators should be included. This should be clarified. And then if we look at the department's response, the regulators were part of the steering committee that was to develop the bill as confirmed by the ports regulator. However, another forum is set up to look at finalizing the business case and implementation plan. All affected regulators have been invited to form part of this task team. Before the declaration is made by the minister to include a regulator as empowered by clause 4, the respective regulators will be consulted. Then clause 411b provides for such grounds. In the main, the operational, financial, personnel, and technical capabilities of the Transport Economic Regulator will be assessed for readiness and viability to house additional or more regulators besides the identified. These are by nature and form identified as economic regulators with related principles and attributes related thereof. So the department is of the view that the proposed new clause allows for consultation before inclusion, and here that the minister must look at the entity's abilities. Here we'll also see that before the minister may consider making the determination, they must publish the relevant report of the capability of the transport regulator. They must also publish in the Gazette a notice that such a determination is being considered and invite public submissions, and may conduct public hearings on the matter in appropriate circumstances. So, Chair, that is what members proposed in the A list, which is that new clause 4, to make provision for the phased-in approach into the bill. I just want to go to the next page quickly just to make sure we've covered everything. So here's another few comments there on clause 4, Chair. It's the same one here. They just say that Western Cape, it's unclear what other types of regulators are envisioned. It should be clarified. They proposed that the word regulator should be inserted after the words any other. And the department accepted the insertion of the word regulator after the words any other. Therefore, only economic regulators will be considered here. And then here, Western Cape again asks for a correction of inconsistencies in references. And here the department indicated that they do agree. Section 11C should change to section 11B. The opposite is true. So, Chair, that is the clause 4 comments for members' input.
The members' input is that, Chambers.
I think my hand was too much. You were about to say something. I feel bad. Maybe I should withdraw and hear you first. Or should I continue?
Continue, Chambers.
Okay, thanks, Chair. Now, Chair, I think the Western Cape Department there is really taking us back. They didn't pick it up the first time. That was the insistence of the committee. And therefore, I think the first issue of the minister and regulating that is explained by the department, our proposition should stand. The last part, which is, I think it's 11B or 11C, I wanted to request that advocate makes us read it. What will it say as their department is agreeing there? What will it therefore read? But in terms of the others and what criteria and so forth, I think that that comment is a bit belated. We applied our mind there, and I think we should stick to what we proposed there. But I would like clarity in terms of this 11B and C, which was the last input. Thank you, Chair. And then if you allow me, once that clarity is given, one can be able to comment precisely on the last comment. Thank you, Chair.
Thank you, Honorable Manu, Advocate.
Okay, Chair, so if we look at 11A5, for example, here, where they say regulator after the words any other. 11A5, let's go there. So here's where any other, so it should be any other regulator. So that it focuses on regulators, not other types of entities to be included. That's the one. Then if we look at 11B and C, so here they basically want to swap B and C because they indicate here that 11B is that the drafting of the report is triggered once the minister has determined that the regulator must form part of the other regulators must form part of the economic regulator. However, clause 11C1 states that the report must be published before the minister may consider making a determination. So if we swap B and C, members will see here B reads, if the minister has determined that one or more of the regulators referred to in A must be incorporated, the department must produce a report after conducting a review, including initiation of legislative reform within 3 years from the effective date thereafter. However, C reads, before the minister may consider making a determination, the department in the prescribed manner must publish the relevant report and call for comments. So Western Cape is saying that you can't have the report first. You must first have the consideration. And the department indicated there that those two should be swapped over. So Chair, that the department can also just clarify if that is their view and that is the understanding, that they will, then we will move what is here in C, will just be moved above B, and then B will become C. I hope that helps, but I'm sure that the department can also come in here, Chair, and just indicate why they agreed with this move, and if it does flow better to first publish and get comments before the minister considers. Thank you, Chair.
Thank you, Advocate. Honorable Manu, your final take.
Thank you, Chair. On the first one of adding the word any other regulator, I'm in agreement, it doesn't do any harm. On the second one of swapping them around, I don't see anything wrong there. However, if it assists the flow, as the advocate is saying, even there, my attitude would say, as long as we keep the wording as it is, if you swap B and C, there is no harm at all, if that's what is agreed. So that would be my final input. Thank you, Chair.
Thank you very much. Mayor Richard.
Thank you, Chairperson. Yes, we just want with regards to the switching of subsection B and C. Member Mr. Marcos basically stated what I wanted to say. As long as the substantial content of the clause remains the same and the actual wording remains the same, if the department is in agreement, then those clauses may be switched just for sequence purposes, but the content of the clauses remains the same. It's just for maybe for better flow, as suggested by advocate now. So we are in agreement with the advocate in that regard. Thank you, Chair.
Thank you, Mayor Richard. Mr. Sikudo say.
Thank you, Honorable Chair. Hopefully I will assist. If you read clause C in any particular day, it may be interpreted differently. But read clause C as before the minister may consider making a determination contemplated in paragraph 1. So it does give that instruction that before 411B is decided, is handled by the minister or is implemented by the minister. Therefore, section 411C applies. After careful consideration in preparation for this meeting today, Chair, we would want to maintain the way it is reflected here, and also confirming that the changes, if we do eventually swap the clauses, the wording will remain the same, except that we would have to amend 411C A there to reflect possibly B, and then 411C1 where it says must publish the relevant report contemplated in paragraph B, would have that alphabet will have to change, Chair. But with careful consideration before today's meeting, Chair, and obviously after having submitted our input as the department, we are comfortable that the way it is captured here, it is correct. Obviously, it's the matter of interpretation on any particular day. When you read clause 411C, in part, you don't read it in full because it does stipulate that before the minister articulates on the A, then the department will then prescribe the manner in which this matter is done, Chair. So those are the changes that we would want to reflect for consideration by the committee, Chair. I'm not sure whether I'm helping here.
Yeah, no, you are being honest. to the process. Thank you very much. This matter has been concluded. Honorable Mangu suggested a way forward, which was in agreement with Western Cape. Is there anybody who feels that the new consideration by the department should be considered, or anybody that wants to second the proposal by Honorable Mangu? Honorable MacDonald? Or you are seconding? Thank you very much. Advocate Almanel?
Thank you, Chair. Okay, let's move on here. Okay, big jump to clause 47. Okay, let's go to clause 47. Oops, 50. There we go, clause 47. Just want to get to the same clause in the bold. This is on the council members and the appointment to the council. Oops. There we go. The Western Cape, for clause 47, amendment set out in paragraph 2, omitting 3 and substituting 5. Amendment seems to be incorrect. Correct reference seems to be subsection 3 and not 5. Thus, the clause should remain the same. Subsection 3 deals with the qualifications that members must have. Subsection 5 deals with the fact that members are appointed on a full-time or part-time basis. They are proposing that the proposed amendment is deleted. The department's response, what's captured in the A-list is correct, due to 2 clauses added on page 26 after line 25. Therefore, our cross-referencing starts from number 5 and not number 3. Then moving to the amendment set out in paragraph 8 of clause 47, 47.12b. Amendment seems to be incorrect. It's unclear how a member of the council can contravene subsection 13. The department's view, subsection 47.12b of the bill provides a clear response to this matter. Let me just go to those first here, paragraph 2. At 3 and 5, that was because there was insertions that changed some sections. And then here, paragraph 8. Paragraph 8. Again, because of the insertion of those other 2 clauses, it had to go to 13 because we added this clause 3 and 4. So if we look at the reference here, Western Cape believes section 3 deals with qualifications. But if we look at the new section 3, then it deals with Parliament's involvement to the appointment of the council members. And if we look at subsection 5, that will, obviously we won't have this new 5 in here. But subsection 5 is here, it's full time, but if we add 3 and 4, a new 3 and 4. Then it's 1, 2, 3, 4, 5. And then it's here, the member of the council, when viewed collectively, must comprise sufficient suitably qualified persons. I hope I didn't make members a bit more discombobulated. Again, section 13, 47:12. Member of the council ceases to hold office before the end of term. What happens there? That has changed. So we can just get clarity from the department if they are happy with those ones. The department believes that the bill and those additional sections are referenced correctly and deal correctly with the contraventions. They are saying there 12B is the clear response. And if we look at 12B, it's how they remove the members from the council. So members, on this one, the department did not agree with these proposed amendments from the Western Cape for those additional 2 clauses, and then it's more a numbering to make sure that the numbering falls in line and the different clauses refer to the correct subsections of that provision. Chair, just going to pause there before I go to clause 54.
No, advocate. We are not discombobulated at all. Very clear. Let me get hands. Any taker, are we happy? Advocate, I can promise you that there are no issues on this one.
Thank you, Chair. Then going to clause 54. Clause 54. It's to omit or must in the bill. Clause 54 in the regulations. Let's just get that one. Page 29, line 34. 34. So that is in our A list. We're deleting that. So it's going to read on any matter which may be prescribed under this act. Now the comments, Western Cape Department, the word must should be retained. It's common to have a provision that says that a minister may make regulations on any matter which may or must be prescribed under the act. They are saying that the proposed amendment in the A list be deleted. The department's view, keep the word may, because not every matter may require regulation for the minister's determination. So that is clause 54 on may or must. Members will recall we had the discussion when we did the drawing up of the A list on why when it comes to regulations, the department felt that the phrasing should just be that the minister may, already there, it's already there, minister may, by notice in the Gazette, make regulations on any matter which may be prescribed under this act. So I'm going to pause there for members' input, or if there's any clarity that members would like the department or the legal drafters to provide.
Thanks, Advocate. Members are okay.
Then, Chair, the next line Schedule 1, consequential amendments. Amendments set out in paragraph 23, amendment of section 13(2)(b) of the Airports Company Act. If we go there, Schedule 1. Schedule 1. Get that line again. Paragraph 23. So it's from lines. And the view here is that the word lines in paragraph 23 of the description of the amendment should be changed to line. And the department indicated that they do agree to that amendment. This would be, if we look at the one here at the top on page 38 in line 22. And this one is on page 38 from, it should be from line 28, not from lines 28. Otherwise, you need to say from lines 28 to up to what line if you want to have that reference. So the drafters can just indicate whether the use will be from line 28, as suggested by the Western Cape, or if they would like to keep it lines. Chair, that's most likely a drafting question there.
Advocate, I'm here. I'm looking for any hand as you suggested. Mayor Chairman.
Thank you, Chairperson. Yes, it appears to be an unforced drafting error. We are in agreement to change that wording to the word line. Thank you, Chairperson. That will be done in the further amended A list. Thank you, Chair.
Thank you. Thank you very much, Advocate.
Thank you, Chair. Then on to the next submission from PRASA. On the principal matters, members would have seen in the notes as well as this matrix indication, there was a few concerns raised by PRASA on areas or policy areas that they felt were not catered for in the bill. So they lay these ones out, and the department's view on the first one, for example, the bill does not address the issue of the investment required to level out the playing fields. Then the department indicated that it's not the scope of the regulator to do to deal with these concerns raised. It is the scope of PRASA. And the purpose of the Act on page 8 does emphasize and promote investment on infrastructure. So if we look here, section 3(1)(f). Purpose of the Act, amongst others, are 2(f), promotes appropriate investment in transport facilities and services. So the department's view is that it suitably will cover investments or taking into consideration new investments or investments required to either level the playing fields or to promote the provision of the transport. So Chair, I'm going to carry on with the general comments. Process support section 4. But we caution that the opening up of passenger rail should be phased in to harness the development of strong rail public transport sector without destroying current operations. The comment is noted. It's likely to be made, the bill is likely to be made applicable to PRASA, as PRASA may be determined as a single operator that controls more than 70% of the market. or that preconditions for competition in market does not exist, access to facility and PRASA being a dominant player. The department indicated that the comment is noted. So those were just general comments that PRASA made. It's not specific input to specific clauses, which is the next ones that we're going to get to. So Chair, if members are happy with the departments and the members noting those concerns from PRASA, then I can get into the specific clauses that they made recommendations on.
Advocate, my members are happy.
It's 12 hours.
Please continue, Advocate.
Thank you, Chairperson. Then members will see PRASA made a proposal linked to the definition of economic regulation. So if this computer, if we go to economic regulation, we have it there in the definition of the bill. PRASA suggests that the term entity should be defined to circumscribe the regulated entities. The department indicates that they do not support the proposal. That the department can give some more input on why they don't think entities should be defined, but members did see that it is number one, it's a phased-in approach in terms of which regulators join, but it's also a phased-in approach based on how the entity builds up capacity and is able to regulate more modes. Then obviously more entities in those new modes will be affected. They would need to get the regulating powers of that mode first before they can obviously deal with that, and defining or highlighting exactly which entities are to be regulated may cause a bit of an issue with the flow of that process. But I think the department can possibly describe it a little bit better. Then PRASA suggests here that the definition be reworded as follows. Economic regulation means, in respect of this act, the regulation of entities, not markets, facilities or services within the transport sector by determining A, the price control for access to facilities, or for B, access to facilities or services and service. The department indicated here the definition could be reworded as follows. The economic regulation means, in respect of this act, the regulation of markets, entities, facilities or services within the transport sector by determining A, the price control of access to facilities or for services, and B, access to facilities or services and service. The word markets should not be deleted. They do agree to adding the words in respect of this act. So members then, in terms of the economic regulation, they are proposing in respect of this act to come in to that first line here. So it's going to be line 37. Should get an amendment if members agree with that. Chair, just going to pause there.
Advocate, I'm just going to take it from there and check what members are saying. Honorable Manu.
Chair, yeah, thank you very much. Well, I think the department's approach is a nice one to say doesn't cause any harm, because I don't know which other act this could be referring to other than this act. So I agree also that it doesn't do any harm. Let's support the response of the department as it is, their rejection of markets and the inclusion of in respect of this act. Don't know what difference it makes, but it doesn't make any harm if it keeps everybody happy. Thank you, Chair.
Thank you very much, Jambase. Babu Keta Mabala was to le.
Thank you, Mangete. Honorable Chairperson, I think the department must clarify, because the recommendation from PRASA says they suggested that the term entity should be defined to circumscribe the regulated entities, But the department say nothing. They say they don't support the proposal. What are they saying? Because if they don't support, they must tell us what is their view on that one. Thank you very much, Chair.
Thank you very much, Mondise.
Yes, Honorable Chair, I'm still here.
What are you saying on that one?
There's a few points around that matter, Chair. Firstly, we do not have a definition for entity as it is suggested here that we should have a definition for entity restricted only to regulated entities. So there are two components with that sentence or that comment. One, it says consider having a definition for an entity. If indeed you consider having a definition for entity, it should only be restricted to regulated entities. On both angles, Chair, is that, as you would know, that you don't want to have a definition for every word that you have in the bill. So you look at high-level definitions that would improve the bill or the implementation of the legislation itself. So on that basis, we don't want to factor in a definition for entity. For example, Chair, a regulator is an entity. Regulated entities are entities as well. And therefore, if you follow their comment to say we need to restrict it to regulated entities, we will lose the whole objective of opening up the scope of economic regulation, not only to currently regulated entities, but to those who may be regulated by the determination of the minister at some point in time, Chair. Because the current status is that we have entities which are not regulated. For example, the PRASA itself, it is not regulated. And therefore, if you limit your definition to say regulated entities, it therefore means that you may want to then avoid regulating entities which are currently not regulated. So my comment on the last part, it's in relation to Section 4, which is the scope of the bill itself, that says those who are regulated now will continue to be regulated as regulated entities, and therefore in future, whether medium term or long term, then the declaration will be made to basically regulate other entities. So in a nutshell, Chair, we don't agree with including a definition for an entity because it may be too limiting, because regulators are entities. You may have complaint organizations from the private sector who would be entities as well. Regulated entities themselves are entities as well, Chair. So we want to leave that terminology open so that at any eventuality where we want to focus on a specific entity, there's no limitation to the legislation in the implementation stage. And we would confirm that we not comfortable to restrict, if indeed you agree to have this definition as entity, to restrict it to regulated entities. Chair, thank you so much.
Thank you very much, Ndate Mieketsi. That settles this part. Advocate.
Thank you, Chair. The next one, PRASA is suggesting that there needs to be a definition for the president. And then the department indicated here that insert definition for president as the president of means the Republic of South Africa. So I'm sure, Chair, that should be the definition for president is the president of the Republic of South Africa. The drafters can just indicate if members are in agreement with adding the definition of president, how they will formulate that, because it does indicate here that in section 43 of the bill, this reference to the president is in the bill. If there's a need to add definition of president, then Chair, they would just need to give us the phrasing.
Yeah, ne? Definition of the president. Let's hear, members. Are we happy? Any taker? Babu Chambers.
Chair, thank you. No, I don't agree. I don't know why we want to define a president in this legislation. I really think here they're clutching at straws. Maybe there could be a reference somewhere, I don't know, but really, Chair, to define the president now here, I think it's really going a bit far. That's my view, Chair. But if it doesn't do any harm, yeah, but I don't think so.
Any other different view? None. Thank you very much. Advocate, let's move. We may pick up a pace a little bit. It will assist us, Advocate.
Thank you, Chair. Chair, then again in definitions, there was a recommendation to amend again economic regulation. The department indicates here that the proposal from Dr. Blackmer is noted, but it's already addressed in clause 3.1a and 3.2b. There's no need to modify the definition for economic regulation further than what the clauses provide. Then again, there's a proposal to add a definition for the ports regulator, and the department's view was that the ports regulator will not be in existence after the establishment of this regulator, thus the definition will serve no purpose. And then again on the next definition proposal to add propose the inclusion of the regulator may enter into agreement with a licensed operator or party to an agreement or a port user for the variation of any tariff contemplated in subsection 1. The department indicates that item 16C 7B of Schedule 1 in page 37 deals with this matter, and therefore there's no need for this additional inclusion. Chair, so that is those ones on the definitions, those first 3 lines, before I go to the Freight Logistics Association.
Let's move, Advocate.
Thank you, Chair. Then Freight Logistics Association proposes some issues with section 3.1d on page 8. The terms of the bill introduce another level of restriction on private sector commercial transport operations by empowering the civil service to apply restrictive regulations where there is no proven need for them. The department did indicate here that the bill aims to deal with abuse of market power and monopoly. It's not intended to stifle the economy nor increase the level of compliance to legislation unnecessarily. No suggestion is made, but the comment is noted. Then on section 3.2a and b, they recommend that the title of the bill is economic regulation, but it includes further social engineering. This patent interference and manipulation of competition, where there are absolutely no current obstacles to the market. The department's views on this is that transformation and advancement of broad-based Black economic empowerment are key pillars of the country. Thus, it's unavoidable. And it is difficult to understand the view of the Freight Logistics Association that there is competition in the transport sector when the rail and port sector have attributes of monopoly and monopolistic behavior, which market failures. So, Chair, I don't know if the department would like to clarify that, or if the members need clarity on that, or if the members agree that there remains a need to regulate these sectors as well. Just before I go on to section 4.
The department.
Thank you, Honorable Chair. If you look at Freight Logistics Association comments on the comments line, it basically indicates the development, basically the purpose of the Act must pursue the development of SMMEs. It must achieve equality through measures designed to advance persons or categories of persons historically disadvantaged. We basically say that the bill itself indeed aims to basically deal with issues of transformation and advancement. And it is important that under purpose, the two layers that I've read, Chair, are critical at one given point in moment where there would be a need for transformation and advancement in the transport sector, Chair. The second comment, which is under recommendation, Chair, it says this is a patent interference and manipulation of competition where there are absolutely no current obstacles to the market. As you would know, Chair, that the current clause 4 basically says entities that are regulated currently would continue to be regulated, which have been viewed to be of monopolistic in nature, but also when the scope is extended to other entities, the focus will be to ensure that we deal with market failures, wherein at the most entities that are monopolies in their specific markets and sectors would then be made subject to regulation by this bill, Chair. So indeed, the bill supports the mechanism of increasing competition in the sectors that we're talking about, Chair. Thank you so much.
Thank you so much. That is kudo. Members, anybody who has anything? Ubaba Ulisa Gamangu.
Chair, I thought I wouldn't comment, but I think the Freight Logistics Association's comments should not be accepted. The purpose of this bill, which is long overdue, is very clear, and let us not accept their proposition. Thank you, Chair.
Any seconder? Chambers, do we still have other members with us here?
I was about to ask that question, Chair. If your members are still here, maybe let me second.
Yeah.
Okay, Honorable McDonald.
We are here. Silent means concern.
Chairperson,
Okay.
I support 100% what Honorable Manu has raised, and I support him 100%.
Thank you very much. Any other view? None whatsoever. Advocate?
Thank you, Chair. Then section 4, they also made comments on the scope of the bill, indicating that the bill fails to define which sectors are to be regulated, why they should be regulated, and how regulators of each mode will function. As it stands, it can apply economic regulation to anything from donkey carts and taxis to bulk railway operations without specifying how or why. The department did respond here to say that the scope of application is clear in section 4, and it does indicate that those areas regulated now will continue to be regulated, and new areas with monopoly and market power will be considered for regulation. Members will recall that the bill does provide for the market studies and the like to be done before sectors are regulated. So in order defining it from the start would defeat the purpose of looking at future or including future areas that may need to be regulated because the monopolies do arise as they continue. So, Chair, I think that's really tags on to the above ones as well in the previous comments for section 4. Just still with section 4.2, they recommend that the bill gives sweeping power. Well, they do say here that the bill gives sweeping powers and authority to the minister, which has a deplorable 30-year history of creating impractical and ineffective commercial transport regulations, and it fails to provide adequate description of any identified need for such actions. The department indicated there's no need to make changes to section 4.2 on page 8. It is a futuristic clause in case monopolies exist or arise. So Chair, that is section 4.2. Then, Chair, I'm sure members are okay with the department's views on those ones. Going to clause 2.5, it speaks of the insertion of the word processing in section 2.5 to read the access, protection, processing and dissemination of information. So this is for the PAIA and POPIA Acts, and the department does indicate here that they do agree and accept the proposal. So that's clause 2.5. Let's go back up here. So this is where we will include processing. So it's not just accessing, access, protect, and disseminate, but it's also when they do process it. The action of processing information is also protected under these pieces of legislation, hence their proposed inclusion of that. And the department is in agreement with that, Chair. So we'll just need members' view if they also agree with adding the word processing after protection.
Advocate, thank you. Let me see if members are here. So members agree, advocate, can we move?
Thank you, Chair. Then our new clause 4 comments that they make there. They note the proposed amendments, their recommendation. There are no transitional arrangements that address the fundamental change in the nature of the regulator and decision-making on price regulation. The department's view on this, in terms of the fundamental changes to the nature of the regulator, the new law will be applicable with regard to structure inclusive of the CEO and the executive officers. This will occur with regard to the operational and technical decision-making, which includes tariff determination. Currently, the bill caters for continuation of the decision-making of tariffs, however, by a different collective. The different collective is now the executive panel. In view of the above, the comments are not making, or the department does not propose any recommendations to clause A in the A list. So, Chair, I think from this one, they are just concerned that if you are going to include, for example, CBRTA, later on, what is the transitional provisions going to be and how long will that incorporation of that new entity take into this entity? The department feels that the clause is sufficient to cover those concerns, but members can also just give their input on this, on those transitional or possible transitional concerns.
Baba Ujambas.
Asikho bemanget, nobas by two asikho. My view is that this is covered in the provision. I just forget the clause itself or the section where we say the department will produce a report and so forth and so forth. That B and C we were arguing about whether it's a C or a B before. And then the minister, in publishing those regulations, in my view, would have had enough information to know the state of readiness of that entity and as advised by the department. And therefore, I do not see how this should be put in the actual piece of legislation before us. So I believe that this is well taken care of. And I think we should not accept this particular proposition. Thank you, Chair.
Thank you very much, Honorable Manu. Any different view?
Let's forge ahead, Chair.
Mkhayesu. Thank you very much, Mkhayesu. Advocate.
Thank you, Chair. Then Ports Regulator, Clause 29. The concerns here is that it's established as a constitutional body and not a Schedule 3A. And that Section 29 also makes provision for two levels of regulator decisions: governance decisions made by the board and regulatory decisions made by the executive regulatory panel. Committee is invited to consider inserting a new Section 38 on accountability. The department's view is that Section 29(2)(b) reads as follows: is independent and subject only to the Constitution and the law. This is not true that the regulator will be established as a constitutional body. In any case, in the business case, the regulator will be established as a Schedule 3A. The roles and responsibilities of the board is only on governance. That of the CEO is administering the regulator, whereas the executive panel has decision-making powers on economic regulation matters. Chair, that is the department's view. They do not believe that there needs to be an additional Section 38 on accountability, or a need to specify that this is established as a Schedule 3 or specified in the bill specifically. Chair, then can I just do Section 10 as well? Then this page is done, Chair. They do indicate here to make provision for cessation, transfer, or assignment of access rights to be reported to the regulator, and the department indicates that this matter is addressed in Section 7(2) on 10. Thank you, Chair.
Advocate, thank you. There is a brown hand, which looks like exactly my hand. I don't know whose hand is that one? Let me recognize it.
Thank you, Chairperson. Chairperson, the clause 29, which takes up the situation of the establishment of the ports regulator as a constitutional body, opposed to the proposed formation of the economic regulator, which would take the form of a Schedule 3A, is indeed a change. Amongst the future economic regulator, under Section 3A, a lot of other, in fact, the majority of the Department of Transport entities are currently listed. Therefore, I don't see a reason to consider anything else, but to accept the change from the current status of the ports regulator being a constitutional founded institution to a then future Section 3A inclusion, and therefore I would propose that we accept it in the design. Thank you, Chair.
Thank you very much. Honorable Hunsinger. I don't see any other opposing hand. Therefore, I wish to say, let's forge ahead. Okay, maybe before we forge ahead, I think we need to stop here. I know that may actually cause a bit of a problem in terms of our programming, but it is what it is. Unless we fail to deal with other items. Valerie, you see I'm trying my level best, but I still need to go accordingly. Item number 3, we will have to get some time and finish this item. Item number 3 is consideration and adoption of committee's report on the International Convention on the Civil Liability for Bunkers Oil Pollution Damage for the year 2001 in terms of Section 231, subsection 2, and of the Constitution. Report of Portfolio Committee on Transport on the International Convention on Civil Liability for Bunker Oil Pollution Damage, 2001, dated the 1st of March, 2022. The Portfolio Committee on Transport, having considered the request for approval by Parliament of the International Convention on Civil Liability for Bunker Oil Pollution Damage, 2001, referred to it, recommends that the House, in terms of Section 231, subsection 2 of the Constitution of 1996, approve the said convention. Can I get a mover and a seconder for this report in this committee, please? Baba Ujambas, your hand is beautiful. Let me hear you.
Thank you, Chair. I move for the acceptance, adoption of this report in this committee. Thank you, Chair.
Thank you very much, Ujambas. Let me get a second.
Honorable Chairperson, I second Honorable Manu. Thank you.
Ndabo Ramadwa. Thank you. Item number 4, consideration of written submissions received on the Railway Safety Bill and the Transport Appeal Tribunal Amendment Bill. We have received written submissions which are around 23, if I'm not mistaken. I call on members to give their views if this is sufficient so that we can commence with the consideration of what is written. Any proposal by members? Or is this 12? Stakeholders, let's move up. Okay. Valerie, you want to say something? It's about 4.
Yes, Chair, I've indicated to you that the Gender Commission's submission came late after the closing date of the 18th. And I would like the committee's view if this should be included as a late submission for on this particular bill.
Okay. Let me hear members. Normally we do accept late submissions. Wow, we have Mukhayesu, followed by Honorable Nsinger.
Yeah, Chair, no, you took the words right out of my mouth in as far as the acceptance of the late submissions is concerned. I think the more submissions we have, the better for the committee. I don't think it inconveniences us in any way. So let us accept the late submission as presented by Valerie. Thank you, Chair.
Galeboa Mkhayesu. Mhlegas. Honorable Nsinger.
Thank you, Chairperson. Chairperson, I have no particular reservations, and therefore, on condition of acknowledgement that it was after the deadline, let's accept and make the content count equal to the others. Thank you, Chair.
Thank you very much, Honorable Member Nsinger. We step off that item.
Chair, Chair, apology, just one issue. Can we have a seconder for that proposal, Chair? Because I see Mr. Mabena is in the meeting. So I would assume Mr. Winsinger.
Oh, okay.
Yeah, so we need
Thank you very much. Hey, Valerie, man. You see, when Mr. Mabena is so quiet, I'm just praying very hard that he should be quiet up until I close the meeting. But you are right. Any seconder?
Honorable Chairperson, I second.
Thank you. I did not see that, Valerie. Thank you very much. Let's deal with the minutes of the meeting that was held on the 22nd February 2022. I have gone through the minutes of the meeting. Any mover? Babu Chambers.
For the record, Chair, I've also gone through that. And I therefore move for adoption of the minutes as a true reflection. Thank you, Chairperson.
Thank you very much. Chambers, any?
Chairperson.
I second the Chairperson.
All of the above. Honorable Matwa and Honorable Stole, 2 seconds. Now let's come to this item, the very important item, which is the last item. There is a report on the proposal of our oversight program. It will be nice if we adopt this proposal so that the necessary arrangements could be done. Yeah, Valerie, is the record of our decisions, eh?
Chair, yes, after our discussion on Friday, Chair, I've included the Northwest as one of the points that the committee will visit for the ITPN and the roads oversight. So in terms of the program, Chair, it will then start on the Sunday of the 27th for members to travel. And I've indicated to you the reason why. Originally, when the committee discussed oversight, Chair, there was an oversight week running from the Tuesday to the Friday. The latest update in the program indicate that on the Thursday, basically in the middle of that week, there is now a caucus and the questions to the Deputy President. So in order not to make members lose a day, the application that will be forwarded to the House Chair and the Chief Whip for approval, Chair, request that the committee use the Monday, but there are issues around the Monday because it is a constituency day. So the Monday, the oversight starting on the Monday, on the Mulatto Rail issue, followed by oversight with Sandro on the Mulatto Road improvements. Then, Chair, on the Tuesday, it will the DLTCs, followed by a debriefing session with the RTMC and a meeting with the Road Accident Fund. And then, Chair, on the Wednesday, starting with the Rustenburg Northwest leg on the oversight there. The issue now, Chair, is the Thursday. There's caucus and there's plenary. I know that some of the members are required to be in the House. So obviously, if the committee continues to have oversight on that day, the Thursday, the 31st, it will need the approval from the Chief Whip. If approval is granted, then the oversight will continue on that day. If a permission is not granted, then it will be the Friday, the 1st. But that all of this, Chair, depends on approval from the House Chair and the Chief Whip, that Thursday program and the Monday program. But Chair, we've included your comments on Friday about the request to include the Northwest. And further, Chair, I'll discuss with Advocate Nel. You also said you want to do a road program. So we were looking at possible areas for oversight to see which roads then will be part of that. But it would also be great to hear from the member in that province if there are any suggestions in terms of which roads could possibly be part of that oversight. So that is the program, Chair. May I also said that the initial program was drafted on the basis of the APP, where members basically indicated the GP Mpumalanga leg in the first term and the Northwest one on the second term. But Chair, from a logistical and a financial point of view, it makes sense to have Northwest included with the Gauteng Mpumalanga leg so that the committee doesn't spend money again in the second quarter to go back to the Northwest and then can rather focus on other provinces. So financially, logistically, it can work and it will be cost effective to include the Northwest. And we would like to have this application to house chair and chief whip as soon as possible. So Mrs. Maslach just asked us, Chair, to please ask members to send the availability as soon as possible so that we can get the quotes, because at the end of the visit, we want to avoid any audit queries, and we want to get the applications in as soon as possible to the decision makers in this regard. That's all from me, Chair.
Has the chairperson disappeared?
I am looking for Chair now online. It seems like that Chair position. Okay, it's Chair, yeah, okay.
I wouldn't make a mistake on this one. I'm here. I can see that my prayers have not been answered. Honorable Sithulo, Honorable Chris Hunsinger, Honorable Umhlonishwa, Ubaba Omapena, and who else wants to speak on this matter? So that I close this matter nicely. Honorable Keta Mabala, and I will close by Ubaba Lisa Wagwama. In that order, please.
Chair, thank you very much. I think Valerie called me by by name, although she mentioned the province. But granted that I am from the Northwest, and I welcome the addition of the Northwest province, in particular the Rustenburg's IPTN project for oversight by the Portfolio Committee. I think that it is long overdue in respect of the news coverage on what has been happening in that particular municipality as far as the project is concerned. I also want to indicate that I think it would be an injustice of some sort if one did not highlight the disastrous conditions of roads in the Northwest province. But I want to put to the committee through you, Chairperson, to say there are two petitions that were submitted to the Department of Public Works and Infrastructure nationally, which dealt specifically with two roads in the Greater Taung local municipality under the Ruth Mompati district municipality, which were roads that were due to be constructed by the Department of Public Works and Roads in the Northwest province, which is currently being under administration for over 2 or so years now. Those roads have, one has cost the department way over 45 million without any work being done. The other one has cost the department over 18 million without any work being done. And I would want to put it to the committee to say, because these are provincial roads and these are in a rural municipality in the Northwest province, which is where the condition of roads have subsequently deteriorated or are non-existent at this point. I would then like to propose then to the committee that we then do oversight in this particular municipality, specifically in these roads, so that the portfolio committee can get an idea of what is the nature of rural roads in the Northwest, particularly in municipalities that are rural in nature in this particular province. It is quite a stretch, I must indicate, but rural constituencies in nature are quite far from you know, your ordinary Mafikings and the likes. And I do think that as public representatives, first of all, we need to be able to enjoy these particular kind of roads so that we see what ordinary South Africans go through on a daily basis in as far as roads are concerned in the province. So I welcome that addition of the Northwest, in particular the RRT or the Rustenburg Rapid Transport Chair. But I propose also then that we show our commitment as a portfolio committee in going to rural areas to see how South Africans are generally being failed in as far as the construction of provincial roads are concerned, as well as the wastage of money in those projects. Thank you, Chair.
Guys, Honorable Onsinger.
Thank you, Chairperson. Chairperson, I firstly would like some clarity. As the program was explained to us, it was subject to continuation on the Thursday and Friday by the Speaker. So only through permission of the Speaker in being absent for our caucus meeting as well as for questions to the Deputy President, this oversight will continue. No mention was made of a denial of that intention. In other words, if the chief whip feels that the program should be ended on Wednesday, I would really want to include Rustenburg and Northwest in particular. And given that this is scheduled for Wednesday, what would the arrangements look like to return from the Northwest to a place from where we would be able to travel? Would it mean that we can travel on the Thursday early morning? And what is plan B, if that could just be shared with us? More particularly on the oversight and the content thereof, Chairperson, in the 8 years that I've been with the Portfolio Committee of Transport, I cannot recall one oversight in the Northwest specifically dealing with BRT. You will recall that there's been a decision by the AG, Treasury, to then withdraw funding on 3 cities of the 13 which are privileged to have a BRT. Rustenburg, in my thinking, should have been included based on the basis of a debility to execute on this particular mandate. I think this then requires particular intervention by the Portfolio Committee, and the seriousness of us visiting them would certainly be this hopefully be the stimulus to then get them up to speed and then also focus on what has been happening there, how much money has been spent there, and what we could actually see in terms of practical infrastructure. So, Chairperson, 2 points then. One of clarity. What is plan B should the Chief Whip decide not to allow us to continue on Thursday and Friday? And then the second issue, my absolute support for a focused oversight to the Northwest. Thank you, Chair.
Thank you very much. Let me implore the remainder of members who are going to speak to try and be short so that we can accommodate clarities. We are remaining with 8 minutes on the clock. Mhlonishwa, I know we shouldn't be fighting, me and you today, man. Let me allow you to get in, Mhlonishwa Obaba Omapena. Unmute yourself.
No, Chairperson, I am unmuted, but I see that you are trying to manage me strategically, so which is problematic, Chair, because you are the one who always protects me. Now, if I'm abandoned by you, I might as well terminate my membership of this committee because I'm exposed. I don't know, Chair, but nonetheless, Chair, okay, we welcome the oversight, proposed oversight, but okay, first and foremost, I think the Secretariat must be applauded, one, for their proactiveness in terms of ensuring that we pay our respects to the King and the Kingdom. I think they learned a valuable lesson in our last engagement. Safe to say that the report back to the Moloto residents, it's long overdue, almost over a year now, whereas we had promised them that we're coming back in less than 3 months. So, so that is welcome. But here's the challenge, Chairperson. We are already now in our midterm as a committee. So meaning that effectively we're left with 2.5 years. In these 2.5 years, as a portfolio committee on transport, we have consistently visited Gauteng. One could be forgiven to think that we are a portfolio committee of the legislature, of the Gauteng legislature, because we're permanently in Gauteng, whereas we have oversight all over the province. I agree with the previous honorable member, Ukrezo Nsing, and also Honorable Sitlolo with regards to the Northwest. I think so far the committee has visited only 3 provinces. We've been to the Free State. I'm not sure whether that is because the chairperson comes from there, and Honorable McDonald has an interest in Bloemfontein. Nonetheless, we did visit Bloemfontein and Free State. And I think it was strategic when we went there because there was a particular court case there in the show, also Honorable Makosin. But also the immanent in Gauteng, and we visited Mpumalanga. Only 3 provinces, and we're in our midterm. So half our term is gone, and we're left now with the other half. So my proposal is this: we scrap all the Gauteng visits, starting with the RAF. Current chairperson, those of who follow current affairs, there is a current dispute in terms of the accounting standards with RAF. What are you going to do when you get there? Because you're going to get one side of the story. Allow for that process between the Auditor General and the Financial Accounting Standards Board to thresh it out. Then they agree, and then we can go there and do an oversight there. In terms of TLCA and TLTCs, it is an important issue, Chair, but I think Honorable Pete May, I don't know, but we don't want to make a situation where other members' inputs are not taken into consideration. He's been on this issue for Eastern Cape. I think it's about time we go to Eastern Cape, and also we can't be managed in terms of resources, in terms of us going there. It makes financial sense. There was COVID for the past 2 years. There was no real oversight. What happened to that money? So we have to go to oversight. And also the other issue is the issue of KZN. Honorable Mangu raised the issue of KZN in the previous meetings. And that issue has not been taken in onto consideration. So here's my proposal. Quick. One, we scrap the RAF visit, we scrap the PRASA visit. I don't want to say the chairperson has a particular interest, but I think we scrap the PRASA visit, we scrap the RAF visit, including the TLCA, because all of them are in Gauteng. We are going to be a portfolio committee that is permanently in Gauteng. Now, here's my alternative. One, we add KZN, we have Mpumalanga, we have Northwest. In that way, we're going to visit KZN for the first time as a portfolio committee. And we're doing this halfway our term, which is unacceptable in the May. But also Northwest as well, unacceptable. We're doing so halfway our term. Again, the Eastern Cape, we're going to go there halfway our term. Again, unacceptable. Kick all of these Gauteng things towards the other time for the oversight.
You are rounding up. I'm looking at time. I'm left with 3 minutes only, and we have 3-4 members who still wants to say something. Honorable Mapina.
So then let me summarize. One, we go to KZN, we go to Eastern Cape, we do Mpumalanga as planned, we do Northwest as planned. It's not our business in terms of the logistics and whether that one is far from that one. That's none of our business. That is the business of the Secretariat and the people who are in Parliament to make sure that we get there on time and that our accommodation is sorted. We can't be as a portfolio committee be discussing logistics. That's nonsensical. So I think unless if there's someone that has a different view, one of the members.
Okay. Okay, Honorable Mapena. I'm sorry to give you a feeling that I'm managing you. I'm trying to manage time. Let's get the next speaker. Ketamaba.
Thank you, Honorable Chairperson. I think, Honorable Chairperson, my question was asked by Honorable Hansinger because I was trying to check the date on the issue on Thursday. If they are actually denying us to continue on Thursday, what is going to happen? That's what I was just trying to check. Thank you very much, Chairperson.
Thank you very much. Obaba Uketa Mabala. Chambers.
Chairperson, thank you very much. Mine was simple, but maybe one needs to comment on the fear that these things might be denied. I think we've seen many committees going the whole week. I don't know why we are always concerned that our committee is not that important. So let's leave that to you, Chair. My input is very simple. In deciding a road, without underestimating what my colleague, Honorable Seycholo, has said, I was going to suggest that we ask the Department of Transport, okay, we follow the money, the provincial roads grant. We need projects where that provincial roads grant has gone to. And we identify a road or two that is closest to where we will be going. It might be the ones that the Honorable Seycholo has said, I'm not sure. But I would want to say in choosing, let's choose where this money from national, which is provincial roads grant has gone to, and then let's identify those to the roads. Thank you, Chair.
Thanks, Honorable Manu. Honorable Matwa. Ramatwa.
Thank you, Honorable Chairperson. I'm not going to take your time. I just want to support what was proposed by Honorable Mabena of indicating that we can go to KZN, Mpumalanga, and Northwest, because Gauteng is in the middle. So if we want to go to KZN, we can start by doing what is in Gauteng and go to other provinces. But adding Eastern Cape and Limpopo, I'm raising Limpopo because every now and then we are getting a report of the border gate bait bridge. So we need also to do oversight there, because during Christmas, Easter's holidays, there are challenges when there is holidays. So we need to go there and check what is it that is happening and what can be improved there. And I also want to support what Mr. Honorable Seycholo has said on the issue of Northwest, wherein we go to the roads that the National Department has given money to them. Because the president during SONA, he spoke of, I think we need to go there. Chairperson, that's my...
Thank you very much.
Submission.
Okay, thank you. I'm sorry. I thought you were finished. Honorable member, let me just throw my 2 cents of the contribution here. I do still have recommendations by this committee. Gauteng has been part of the recommendations. The reason why I included Gauteng in the program is that on our way to Mpumalanga, there's Gauteng here, and on our way to Northwest, we are likely to offload in OR Tambo. There is a program that is going to link Eastern Cape and KwaZulu-Natal. I think it is in our program. We did talk about these issues. It's not a new issue. There is a program of Limpopo, as Honorable Ramatwa is saying. I remember I included Limpopo when she was even not there. There is a program of Eastern Cape that we had said it will be linked with KwaZulu-Natal. Let me humbly request members that on the issue of whether there is the refusal or not, let me talk to the chief whip and the chairperson of the chairs of chairs and see if we can get granted to see our program to finish. But humbly request that let's leave this program as it is. We are still going to see Eastern Cape and KwaZulu-Natal. We will see Limpopo. We will also see Northern Cape. It's part of the program. So we'll basically see every province. If I may humbly request the members, let me hear what the Honorable Mapena is going to say. Will be followed by Ntate Makosini, and we'll close this matter if there's no any other person.
Okay, thank you very much, Chairperson. Just two quick things. One, I just want to flag it that you're creating a precedent that we are going to speak to Honorable Chair of Chairs, Cedric Frolik, and that in future, because we've had this problem before, where we're supposed to go to Mpumalanga, and we're told that Cedric Frolik wrote a letter to the committee telling you effectively that you cannot take your committee to Mpumalanga, instructing you to do so. So I'm saying, even in future, when Cedric Frolik feels like doing that, you must also, because you've set a precedent, be in a position to engage with him and tell him of the importance of you taking your committee as per your commitments to the public out there that you made as a chairperson. It's important that we flag that for record purposes in the committee. Secondly, there is no member that spoke that agreed with the program chair. Every member put in a suggestion. In fact, no member pushed for us to be in Gauteng. The only issue was the centrality of Gauteng from Mayor Ramat. So in essence, what members are saying, I'm not speaking for them, but they can speak for themselves. We're not happy with this Gauteng thing. We understand the centrality of it. But the issue here is we're tired of being in Gauteng. We want to go to other provinces also vote for us to be in parliament. So unless if there's any member that spoke differently and I didn't understand, no one was supporting this issue of Gauteng. In fact, all members were giving an alternative. So in essence, in summary, the committee is saying they must really look at this program, remove these Gauteng things and prioritize other provinces. Mayor Ramadwa even added Limpopo onto this entire thing. So I'm saying that's what the members are saying. Thank you.
Ntate Makosini, thank you, Honorable Mapena, followed by Mera Matwa and Keta Mabala. Honorable Keta Mabala will then close this matter.
Thank you, Chair. I don't deny the fact that we should go to other provinces. But my take would be, we went to oversight in the Free State, and up until today, nothing has happened. I was there last week. And that province where I come from and where you come from is #1 province in squandering money allocated to service delivery. So my take is I propose that we make a follow-up and not be seen as a portfolio that visit provinces and not force provinces to pay what is due by them to national. Thank you.
Honorable Ramadwa.
Thank you, Honorable Chairperson. Chairperson, I indicated that Gauteng is in the middle. When you want to go to Northwest, you can start from Gauteng. As long as we are having time, because it's not the issue of going to the provinces, but the issue is dealing with the matter that we want to do oversight on. Secondly, I would like to second your proposal for now, because the program is there, and though we are raising our concern, and I hope the issues that we are raising, they are going to be accommodated. But for now, let us do what the program is doing as you are humbly pleading to us. Thank you, Chairperson.
Thank you, Honorable Ramadan. Ubabu Jobe.
Thank you, Honorable Chairperson. No, I'm disagree with my friend Honorable Mapena. We cannot squeeze KwaZulu-Natal. KwaZulu-Natal is a vast province, so now we cannot just squeeze because of visiting. So if you want a the second largest province is KwaZulu-Natal and the Eastern Province.
Okay. I hope it's not my network. It is Honorable Stoller's network. We have in essence captured what he is saying. We will follow the program. We will go to KZN, as I've said. This issue should not divide this committee. It's a very simple issue. We respect the views of everybody, but let the program remain as it is. Ramatwa has actually concurred, and Honorable Ketamabala is also saying the same. In that high note, let's try our level best that Valerie, on your side, talk to the administration. Let's see that the program is carried. I'm sure next week we will be able to indicate how far we are with this program. Are we together, Valerie?
Yes, Chair, but as I've indicated earlier, Mrs. Mashlati is really asking members to get back to her as soon as possible about the availability. That is a very important issue, Chair.
Please, members, your availability to Ms. Mashlati as soon as possible. By next week, we should be able to know who's going, who's not going. We're sorry to have encroached beyond the time allocated to us, but I want to thank the legal team. I think they did very well, Meharicheren and Mepumelele, with our own advocate and everybody involved. The committee for having been robust on issues, including this last issue that always divide us a bit, but it is not anything personal, but we all want to see work happening and visiting all other provinces. Thanks to anybody and everybody that participated. Thank you very much. The meeting is closed. Long live everybody.